Hi, Peter. We have fixed our streaming issue and we are ready to go.
Perfect.
Before you continue, may I just direct you to points 5 and 6 on your notes? I think we might have missed something on.
Yes, yeah, it seems as though the introduction by the development officer launched into the presentation, and I just wanted to clarify that we're back, if that was indeed the complete presentation by the development officer.
Yeah, I believe that was the administration's presentation.
All right, thank you very much for that clarification. So we'll backtrack a little bit, and I'll ask now that the appellant or their agent identify themselves to the board if they're present.
Hi, Dave Clancy's here. I'm not sure if I'm supposed to jump in here.
We can hear you, sir.
Oh, okay, good. Okay, so are we on point number 5 or 6 or? So
we're at point number 5. I am at the moment going through the administrative stages of questions that we have for you before we launch into your presentation and submissions. So before we get started, I just have to ask, do you, Mr. Clancy, have any objection to any of the board members hearing this appeal or hearing this preliminary matter in the appeal?
I'll have an opportunity to talk about my objection to the appeal in general, like later, I guess. Is that right?
That's correct. Yes, we will. There's a number of administrative steps in advance of your presentation.
Okay.
And then I'll ask you for your submissions.
Okay. Okay. Thanks. I don't have any objections to the board members, I don't think. Thank you.
Thank you. And have you had an opportunity to review the agenda package that was distributed to the board and to the parties to this appeal?
Yes, I have the package. I believe I have the package. It's about 70 pages, I believe, and the actual agenda itself and the etiquette that was also sent to me.
And do you have any objections with the information that was provided?
Well, is what they presented. I have objections, maybe, or comments on some of the comments made, I suppose. But I guess is that part of my presentation later, I guess?
Yes, this is more of, is there anything missing that should be included or anything that's in there that shouldn't be in there?
Not that I'm aware of.
All right, thank you very much.
Yeah.
I'll now ask the applicant or their agent to identify themselves to the board if they're present.
Tim Barsley, Mr. Chairman and members of the board. I'm a lawyer at Denton's in Calgary, and I'm here to represent the interests of the Harris family, who are all present as respondents in the appeal.
All right, thank you, counsel. Do you have any objection to the board members hearing this appeal?
No, sir.
Have you received a copy of the agenda package that was distributed to the board?
Yes, sir.
Do you have any objections to any of the information that was provided?
No, sir.
All right, thank you very much.
You're welcome.
Briefly go through the hearing outline to address some of those procedural steps, make sure that we're all in order. The hearing process this afternoon will be as follows. We'll first hear from the administration. That's already happened. Then the appellant or their agent will speak in favor of their appeal or this preliminary matter in the appeal. We'll then hear from those speaking in opposition to this preliminary matter. At any time, the board may interject to ask for clarification from individuals speaking. Following any questions that we might have, we may then ask for a short recess. And finally, administration will be asked if they wish to provide any clarification or closing remarks. Following any closing remarks, the board will then close the public portion of this hearing, and I imagine have a brief recess prior to the commencement of the next hearing. The purpose of the hearing is for the appellant and affected parties to provide the board with information. The board must base its decision on the law, in this case, the acts, as we are not going to be discussing the merits. At this point, I just remind you to please keep your comments and your submissions to the preliminary matter of the board's jurisdiction, and don't delve into the merits of the appeal. Please ensure that all of your comments are directed to the board, and also that we would ask that all comments be of proper decorum and be succinct. So if someone has already made the point that you want to make, simply state that you agree with their point and continue with your submission. If any person during their presentation is referring to a written document, including a map or photographs or a report, please ensure that a copy of these documents are left with the clerk. Mr. Clancy, do you have any concerns with the process as I have outlined it?
Sorry, can you hear me now? No, I have no objections to the process.
Thank you very much. Now ask that you make your presentation, provide us with your submissions, please.
I don't think the camera is on, but I'm not sure if that's necessary. Oh, there it is. Okay. Yeah, okay, so in my presentation, just probably should have made this known initially. I'm the owner of the property right beside the 15 Pinewood, 14 Pinewood Crescent. And I've been the owner there for about 7 years, but I've been involved with the property for about almost 20 years. I originally helped somebody buy it, and so I've been involved for a lot of years. And you know, it's nothing about you know, building on the property. But anyways, I keep it to the appeal issue. So anyways, my understanding, the appeal form was to be filed on November 17th. I'm not sure if you want to, you know, the board, you want to follow along my document, which basically the summary is, I believe that form was required on November 17th. I filed it on November 16th. It was filed on November 16th after hours for Canmore town purposes. And I'm actually based in Toronto, so the 2-hour difference. And so at the time, though, I asked that, you know, somebody could call me the next day, take my credit card for the $250 payment. That didn't happen. I know Louise, the clerk, or I'm not sure what Louise's title is. She did send me an email. I got it on November 23rd. I think it was dated November 22nd. I pulled it out of my security system, and you know, she was talking about the payment, asking for the payment, calling it in. When I pulled it out, it was like 6 o'clock Toronto time, 6 o'clock in the morning, a.m. So I basically sent back an email saying I would do it. And then unfortunately I didn't, you know, do it that day. I forgot, got busy, whatever. And then I think it was 6 days later, on November 28th, she sent me a note that the appeal was denied, or some comment like that, because the payment wasn't received. So in the process, I wanted to pay. I tried to pay. I know for Visa, you have to talk to somebody if you're doing it by phone. So I asked for somebody to call me and, you know, provide the number and the security number at the back, all that kind of stuff, which didn't happen. Unfortunately, she tried to use email. We have a security system. I never got it. The first email, November 17th. I didn't get it till November 23rd, based on, based on seeing the previous email, which was attached to that same email, or same email string. So anyways, yes, it didn't get filed with the actual appeal, but it wasn't without trying, various times. So then, the part that I thought was a little bit unusual, if there was such an urgency to this payment, I don't know why that wasn't relayed to me when I made it very clear I was willing to pay, but, it just didn't happen, because it wasn't, there was notice on that November 23rd is really the only time I actually got the notice about that part of it. And then obviously I forgot to do it. I got busy that day, and then, figured it wasn't that big of a deal. And until November 28th, when they said it was being denied because of that issue, which I thought was, was wrong. Okay, so then basically, as we heard today from the city, or the township, sorry, the Jarrett, he said right away that it was a completed form that was filed on time. And then I think he might have backtracked on the $250 fee part. And that's the issue that I know when the board members rightfully asked, where's this $200.50 fee? Is that in the bylaws, or is that somewhere in the bylaws? And obviously it's not. The form itself is presumably the whole crux of the appeal process. I was thinking afterwards too, like what happens if somebody doesn't have $250 to pay? Does appeal not get doesn't get recognized? If somebody can't pay the $250, it doesn't make any sense to me that all of a sudden, without really any notice that this is an urgent issue of $250, then they can just throw the whole thing out. It makes no sense to me. And and then I know the legal, the legal representation has a couple, case references. One is 2011, which is pretty old, and then right on their sheet of paper, you have 2018 case, but it goes against their argument. So of course that one isn't even shown. So I'm kind of, thought that was kind of interesting. So anyways, bottom line is, it's a matter that some people might think is minor. Obviously the township thinks it's a minor issue. I don't think it's a minor issue. And for it to be thrown out because of this fee not being paid supposedly at the same time it was supposed to be paid, which, the form itself, again, the township refers to in their submission, the form is in the form, the town appeals application form. They of course leave out the written instructions, which, would be presumably part of the attachment, but they don't even put that in. Now, the attachment itself is, for the average person, I wouldn't say it's the clearest, if you're a lawyer or whatever, maybe you can figure it out. But I wouldn't say it's the clearest concept that this payment has to be made with the form or on time with the form. The 250 says, it says here in the very top, it says, or under payment, it says payments may be paid by check to the town of Canmore upon submission. So what does all this even mean? Like, not everybody lives in the town of Canmore who has interest in the town of Canmore. So a check obviously isn't going to be there the same time as the submission. And then it says payment can also be made in person by debit, Visa, or MasterCard at the Civic Center. Same issue. Not everybody actually lives in Canmore. or is available to be there in Canmore to make that submission. So right there, it's kind of a very wishy-washy concept. I did read that at the time I was filing this appeal, and I live in Toronto, or live near Toronto, and you know, it's not applicable for me to obviously fly out there to make a visa payment. So anyways, that's why I asked for somebody to call me, because making visas over the phone is a very normal business transaction. And so I asked if somebody could phone me so I can give them the card number and the security code at the back. So anyway, that didn't happen. Then in the actual form itself, it says, what is the fee to file an appeal? And then it talks again, reiterates payment can be made by check. Okay, so obviously a check, if it's mailed, it's not going to get there the same day. So that's not very clear on that whole issue. I know the town of Canmore, sometimes in the good old days, I don't know how many people do it anymore. They give you a few days grace if you mail a check for your property taxes. But, you know, it's, you know, if you're saying it has to be due the same day, you know, a check really isn't an applicable concept. And then it can be made in person by debit, Visa, or MasterCard. The same thing. It specifies a situation assuming that somebody lives in Canmore or is available to be there in Canmore that day, which is not really applicable. So anyways, you know, it was bad on me maybe to forget to send it or call in to the person that Louise would have given me the number that one time, but it wasn't like anybody made any urgency about the $250 issue. So it slipped my mind, and you know, that's what happened, unfortunately. But having said that, I think it's really clear through all the documentation that I have that I, you know, meant to pay it, always wanted to pay it, and meant to, you know, was willing to pay it, you know, right from the very beginning. And for whatever reason, people nowadays, you know, they want to use emails, and emails, as everybody knows, aren't the most reliable source of communication all the time. And, you know, people have security systems where, you know, emails get lost. You know, the good old days of maybe picking up the phone call, like I suggested, somebody in that office could have done, take my Visa card the next day, you know, should have happened. And everything would have been happy here. And, you know, the Harrises could avoided having lawyers attend these kind of sessions and all the ridiculous aspect of this unfortunate situation. So anyways, it's I think that's the basic concept I have, and I'm trying not to run on here too much. And I guess that's really my point, is there was no intent not to pay it, and I asked to pay it. The town didn't get back to me. I didn't hear about it until about 6 days later when I pulled out the other email out of our security system, and again, you know, I made communication to say I was going to pay it, no problem. And but unfortunately, when I pulled it out, it wasn't business hours, so I couldn't make the phone call right away. So that's basically my position. And but secondly, it's this $250 fee, you know, seems to be a bit of a red herring here. And the actual substance of the appeal is the actual appeal, and the substance behind the actual appeal. And the fee, that's all nice and good, but I don't think the appeal should be based on not getting the fee there exactly the same time as the appeal is filed. The appeal being filed is presumably the substance of what we're talking about here today, and or maybe in a future meeting, hopefully. But to have this thing thrown out because there wasn't a connection between this fee that is not even in the bylaws. There's nothing that says in the bylaws that this fee has to be submitted exactly the same time as the appeal form. It just seems like it's just this arbitrary concept going on here. And, you know, even the form itself, I don't think it makes it super clear that this is a requirement. Actually, I don't think it makes it clear at all that this is a requirement of filing the appeal. yes, they want the $250 before the appeal is heard or appeal is submitted or whatever, but there's no real connection between the actual appeal form and this $250 fee. So anyways, it's I think this being ruled invalid because of this issue is, I don't know, it's kind of a bad situation because it leaves a bad taste in my mouth if that's what local government's all about, where something like this is what causes an appeal not to be heard. And also the representation that it was way after the fact. No, it wasn't way after the fact. It was November 17th when it was supposed to be filed. Basically November 28th is when I got word that this appeal was not going to be heard. And that's why I wrote that other note saying this is not right. And then on December 8th, I got the note saying, the board will hear the appeal to hear the appeal. But you need to have the money in by whatever on December 9th. And I did it right away. And, when I need to know, when I have to have something done, I usually get it done. And, but if it's too, wishy-washy, then maybe it doesn't get done. And that's how I kind of perceive this whole situation for the $250 fee, unfortunately. And I believe it is very wishy-washy how this is actually in, the application form. Personally, it should be way clearer and different, a different process. There should be a way of, like the fact that I had to have Louise send me a note to say, call this person, at this number to make your payment. Well, why wouldn't that be right on the form initially? It makes no sense to me. So anyways, I'm going around in circles, but, I feel this is really totally inappropriate if the actual appeal is not heard because this $250 makes the appeal invalid. It just makes zero sense. And if you want to get into law, I don't think it makes sense either. So, not that I'm a lawyer, so I'm not trying to practice law here. Okay, well, thank you for listening to me ramble on for 5 or 10 minutes, or probably more than 5 to 10 minutes. But sorry for that, and I guess I rest my position, I guess.
Thank you very much, Mr. Clancy. Board members, do you have any questions for Mr. Clancy? Go ahead.
Yes, I have 2 questions. My first question to the appellant is, have you seen and signed that form? And my second question is, why did you not pay within 21 days?
Well, I did pay within 21 days of filing the form, if that's what you're asking me. 21 days was November 17th from the notice that the 15 Pinewood was trying to get the variances pushed through. So yes, I did file everything perfectly by the book as far as the form, and I did sign the form. Yes, so that was all done November 16th, and at that time, when I filed it, I said, please call me the next day, which is November 17th, which is actually when it was due, and get my credit card for the $250 payment. I never got a phone call. And then I didn't find out until November 23rd that they were trying to contact me to call them to give my number to somebody. So yes, the actual crux of the form was filed appropriately, and the only thing we're talking about is this $250 payment, and I did pay that December 9th when I was asked to. Because on November 28th I was told that the appeal was invalid because they hadn't received my $250. But I'd only had one notice, and nobody had said that this is really crucial to get paid right now. So I just got this email about 5 days, 4 or 5 days later, that basically said it's invalid because you didn't call me back in 3 or 4 days. So, did I answer your question, sir?
Yes, thank you.
Okay.
I have one further question. The payment was on December 9th, correct?
Yep. Yep.
And they did accept the payment
Yep.
on that day? Okay.
Yep.
Thank you.
Yep.
Any further questions from the board members? Seeing none, I have no questions either. Is there anyone, Madam Clerk, here to speak in support of this matter?
No, I don't believe so, Mr. Chair.
Thank you. Anyone here to speak in opposition?
Yeah.
Hear from counsel
Go
for
ahead.
the.
Thank you, Mr. Chairman, members of the board. Good afternoon. As I said before, my name is Tim Bardsley. I'm a lawyer at Denton's. Specialty is municipal law and planning. I've been doing it for about 38 years, more or less. Still haven't got it right, so we still keep trying. And anyway, we are here on behalf of the Harris family, as I told you before. They are present. Because this is a legal jurisdictional matter, they've asked if I just make the presentation because it's kind of up my bailiwick, if you will. I would direct you, members of the board and Mr. Chairman, to the fact that we did file a submission for you. And the pages, excuse me, in your agenda where that's contained are from 59 through to, I think it's 76. Let me just check. 77, pardon me. So what I was going to do, rather than read it, is just kind of summarize where we're at and go through this in a little bit of detail. And when I say things here, keep in mind we're presenting a legal position. We're not being judgmental about people here, ever, at all. So the situation here, from the board's perspective, is this. The requirement to file an appeal within 21 days of notice posting is in the Municipal Government Act, as you know, and that requirement cannot be altered, extended, or anything but observed by the municipality because it doesn't have the authority to do that. The facts in front of you are that the notice posting required by the bylaw was done on October 27th. The town staff says the appeal date expired on the 17th of November. I think it's the 16th, but for purposes of the hearing, I'd ask you to accept the town's evidence on that and say it's the 17th, just so you don't have to get into a process on it. The question you have to ask yourselves is what was the situation with the appeal as of midnight on the 17th, that is the end of the 21st day? And the answer is there was an appeal form, but there was no fee paid. So the question then becomes, well, how do you get to the fact that it's legitimate for the town of Canmore to impose filing requirements for an appeal? That's what this is all about. Now, I will tell you that jurisdictionally speaking, from a lawyer's point of view, this is a power that comes to the town through the Municipal Government Act and its authority as a municipal development authority to set rules and regulations pertaining to processes, including filing appeals. The town of Canmore, and I can tell you that this is like every jurisdiction in Alberta does this, is allowed to say, if you want to file a development appeal, you have to do it within 21 days, and here's what you do to file. So they'll tell you what form you need to use, they'll tell you where to send it, and a lot of times, in fact, every time, they say there's a fee. Those are legitimate policy decisions by the town of Canmore. They've been in place for years, just from my knowledge, as they are across Alberta, and they're perfectly legal. So the question becomes, where is an appellant who knows nothing of the system, such as I think this gentleman is in that class, where does that person find this out, that the appeal fee is required? And where do they find out it's required within 21 days? Well, in the material we gave you, we actually took the appeal form that's on the web and reprinted it. So if you want to look at page 64 and 65 for a moment with me. We'll just go through it quickly. And the photocopy's bad, sorry. I have to fire my secretary sometimes when I work from home, which is me. The appeal form itself is the one that was signed by the appellant here, you know that. The very next page, it says instructions for filing an appeal. Contrary to what you've been told by the appellant, I read this completely differently in the sense of saying it is absolutely crystal clear that when you file a notice of appeal, you have to submit the fee at the same time. And if you can see, I don't know if in your copy the highlighting came out, but you can see on the form it says notice of appeal form must, and look at the second bullet, be accompanied by the $250 filing fee made payable to the town of Canmore. Go a little further down, you can see it says please note, appeals must be accompanied by the fee at the time of filing. So with all due respect to the appellant's comments, I think it's crystal clear in the form that you have to pay the fee at the time you file the appeal. That's required, no question. If there's some issue with that still, I'm told by staff, and I think this is correct, if you look on the SDAB website, you'll see the same information. You have to file the fee. Pay the fee at the time of filing. So the town of Canmore, acting as a municipal authority under the MGA, has established these requirements, which must be performed within that 21-day period, because they can't vary that. This is a town policy. The SDAB is not a policy body. So, for example, to give you an idea what I'm talking about, if I came in front of you today on a refusal, say on an appeal, and said, you know that section of the bylaw they refused me on? That's illegal. You shouldn't enforce it. You would look at me and you say, sorry, that's not our job. We are here to enforce the policies as we see, in the context, and enforce the bylaw. If you think something's illegal, you have to take that over to council and get it changed or go to a judge. So you're not in a position today to say whether the policy of the town of Canmore requiring a fee to be paid is unreasonable, unfair, or whatever. It's there. It's legal, and it's part of the process that we deal with every day. So I wanted to make sure we were really clear about that without assigning fault to anyone. That's just the way things are. And in my business, I can tell you, there are certain things that happen that you have to comply with deadlines. And if you don't, you're out of luck. If you know anything about law, if you sue somebody, you only have so much time to sue them. And if you don't do it within that time, you can't. And it doesn't matter why you didn't make that deadline. It doesn't matter. The fact is, nobody can help you with that because there's no power to help you with that because you can't extend the deadlines. And in this particular case, with respect and fair, to be fair to the appellant, it's awfully clear he doesn't understand the system. He doesn't understand the priority of the payments. Fair enough, but when you appeal, the law says you're responsible to inform yourself of what the requirements are, and you're responsible to ensure that they're met. So just for example, when the appellant says, I sent the form to the town on the night of the 16th, I knew there was nobody there, I asked them to call me. Well, they didn't call me. Well, no, but they sent you an email the next day that said, here's the number to call. How are they supposed to know that that's in a security system and he's not going to get it? Why wouldn't he have phoned the town the next day if he hadn't heard from them? He could have done that. You see, when the law looks at these things, that's the analysis you go through. Because at the end of the day, if you don't meet the deadline, nobody can help you because you can't extend it for good and valid reasons. And I'll tell you why this is a policy that's really important. Can you imagine what would happen if somebody decided that, there was jurisdiction to sort of mess with the deadline, if you will, for a good reason? What would a development permit applicant ever have? When would they ever have security to know that they couldn't get appealed? Somebody could file a thing 11 months later and say, well, here's the story, the dog ate my homework, that kind of stuff. Can you deal with that? And there's no certainty at all if you start that. And that is the legal reason, policy reason, why you don't extend these things. It may strike you as unfair or unreasonable, but that's what has to happen for the system to work. And if it doesn't, it just doesn't work, and you can see that. So that's kind of our position here. We agree with your staff. You don't have any jurisdiction to extend the time, which was 21 days late. The fact the staff accepted the money is neither here nor there because the requirement wasn't met. And they did tell the applicant that. If you take a look at the record, you see lots of emails where the staff was quite blunt about it. And I think that if you need to refer to those, I just want to make note of as pages 24 and 25 of your agendas will show you the emails that the staff sent to this individual appellant the next day, that's the 17th, and on the 21st. Now, like I said, how are they supposed to know he's not getting them, right? There's no way for them to tell, and he never said anything for 12 days. Could have been 2 days, it doesn't matter. If you don't do it within the time you have, you can't do it. Now, to that end, and this will be as quick as I can, Mr. Chairman, sorry I'm going on a little bit longer than I thought I'd have to. I want to just go through the law with you really quick, because I'm a lawyer and I'm allowed to do that. And I'm looking at page 60 of our filing, and I'll be very quick with you. The business I'm in has one seminal textbook. It's called Locks on Planning and Practice in Alberta. It's one that we use all the time. Their particular take on this at page 1029 is that if you fail to file an appeal within the statutory time, that is fatal, meaning done, can't be helped. There has been one case that I know of where an SDAB proceeded to hear an appeal which was filed late. And that was in 1977. And we talk about this in the filing at pages 60 and 61. It's a Court of Appeal, which is fairly high up. And essentially, just so you know what happened here is a lady wanted to appeal an apartment approval. She had her neighbor go down to try to file the appeal. And the neighbor went to the City of Edmonton, who said, no, the permit was withdrawn. You don't have to file an appeal. So the lady says, okay. Goes back to the appellant, who says, no, I don't believe that. Go file it. So a couple of days later, this lady goes back to file it, but she couldn't get a parking spot, so she didn't do it that day. And ultimately filed it, but it was late. In other words, over the time period. The SDAB of the day, for reasons they didn't quite explain, but I suspect it was sympathy for the circumstances, decided to extend the time to hear the appeal and did, and made a decision. And then that went to the Court of Appeal. So if you look at page 61 of your agenda, top of the page, you'll find that what we've done is extracted a couple of comments the court made in deciding that the board should never have done that. That is to say, never referred the appeal. The first thing they said was that the agent, that's the person that was going to file this, had sufficient time to attend to filing the appeal within the statutory deadline. Now, in this particular case, you've got 21 days to file your appeal, organize the payment, whatever the case may be. 21 days. Nothing that you've heard today would indicate to me that there was any bar to that placed in the way of the appellant. You know, they take their time, that's fine. But let's not be unclear about the fact they had 21 days to deal with this. Okay, without fault, to say you waited so long, you still wait that long. You know, that happens, right? You leave everything to the last minute. Sometimes things go wrong. So that's the first thing they said. The more important thing they said was they said that, look, in the circumstances they were dealing with in that particular case, with the misinformation from the Edmonton officials, you might think there was a little bit of prejudice there. That's what they said. But then they said this cannot be taken as a justification for a decision having the effect of enlarging the statutory time limit on the appeal, even assuming there were power in the board or this court to do so in a proper case. That's what they said. And I can tell you that since 1977, there's never been a proper case. That is to say, there's never been a case where a board ever extended that time, because they can't. Now, the next thing I did in the brief is I referred you to another case called Marcellus, which is a little different, because this is the way these issues get in front of the courts these days. It's not so much this one as you're dealing with today in terms of requirements. What normally happens is you get things like permitted uses that aren't advertised, so people want to appeal them, but they don't know when they knew, you know, in the 14-day or the 21-day period it starts. So they always go to court and say, I didn't know until this date, and that's when the time should start. In all of those cases, and there are a lot of them, never once do the lawyers involved with them or the judges that deal with them ever say, oh, you can just extend the appeal period. Never even consider it. And that's because they can't, and they know that. So the decision from 1977 is quite valid in saying that there's just no power to do that, irrespective of how heartfelt the circumstances might be that you give it. The other thing that Marcellus said that is very pertinent to this discussion today is that ignorance of the law does not itself extend a limitation period. And there's an old legal saying, it's ignorance of the law is no excuses. You've probably heard that before. Well, what it really means is ignorance of the law is no excuse for failing to obey it, is what it means. So in this particular case, with the appellant obviously not quite appreciating the need to follow the rules and pay the fee and so forth and all the system involved, that's on him. Not on the appellant, not on the respondent, my client, or the SDB office or anybody else. It's his responsibility to make sure he knows what to do and do it. And he made decisions because he didn't think it was, and that's fair, but you are dealing with the fact that you can't help him because of that. The last point I wanted to make, and this is real quick, is just to reaffirm again that you don't have a power to extend these deadlines. Your authority in the Municipal Government Act is in section 687 sub 3. It doesn't include an authority specifically to vary appeal periods. If it did, we wouldn't be having this discussion today, but it doesn't. And if such a thing existed, that's where it would have to be. So my point at the end of the day is I agree with your staff. There is no jurisdiction here for you to extend it, no matter how sympathetic you may be to the appellant's circumstances. There's only really one legal decision you can make, according to the law as I understand it. The last thing I want to just mention to you is my clients are kind of in a bit of a situation here, as you can understand. The permit was released to them, fairly so, because there was no appeal filed. You know, there was no fee. They went and got a building permit, that was approved, and they organized their trades and organized everybody to come and do their work and paid the fees and stuff, all before they were told on the 13th of December that this fee had been paid. So you can imagine the pickle that puts them in. And the concern they have for ensuring that their interests are represented at this hearing. It's really not very a fair situation for their sake at all. And I will say something else. Your staff here, the SDB staff, have done nothing wrong. You know, in that Edmonton case where the staff misadvised somebody, that's not the case here. Your staff have done absolutely nothing wrong. Or nothing blameworthy, I should say, in terms of communication with the appellant here. Even if it mattered, which it really wouldn't, but they didn't. And I think that's important to note as well. So like I said, none of what I've told you is to reflect badly on the appellant. This is just life. But it's very firmly, legally speaking, that you don't have the ability to help this gentleman and extend these periods, and therefore I suggest the appeal has to be just dismissed for lack of jurisdiction. I appreciate you have 14 days to issue these decisions, and I would just ask you that if it's possible, if you could get a little quicker than that, because you can understand the stress my clients are under because of the situation, that's, if you could. With that, Mr. Chairman and members, I'm concluded. Thank you for letting me finish, and I'm happy to answer any questions.
Thank you, Council. I do have one question. It's more of a clarification. You have cited in your brief that, and in your presentation, that there's a section of the MGA that attributes power to the town to set town policy, and I'm just wondering if you have a citation for that so that I can.
It's under the it's under either 640 or generally your natural person powers, which would be, oh gosh, I think it's 9, if I remember correctly, sir.
All right, thank you very much. Members of the board, any other questions for Council?
Yes, I have a question. I'm looking at section 686,
Yep.
sub 1 of the Municipal Government Act,
Mm-hmm.
and it says, a development appeal is commenced by filing a notice of the appeal containing reasons
Yep.
with the board hearing the appeal within, and I'm omitting what I think are
That's
not
right.
relevant parts, within 21 days after the date on which the written decision is given under section 642.
Yep.
So, as I read that, the time, what's required is the filing of a notice of appeal within 21 days.
Mm-hmm.
And there's no mention of paying the
Yep.
fees. So
Yes.
I'm not, how do you read in the payment of, because what the section says is, as I read it, is it's required to contain reasons.
Yep.
And that's it.
Yep.
And it doesn't have to be in any particular form, unless,
Well, there
I mean,
is some, okay, go ahead,
but-
sorry.
hasn't the appellant satisfied that requirement, that he filed the notice of appeal within the
If-
21-day
I'm
period?
sorry, if that's all there was, yes, but there's more.
Okay.
And let me help you out with this, if I could. In this town, if you want to file for a land use change, which the MGA lets you do, right? If you want to file for a subdivision, which you're allowed to do, development permit, they charge fees. And you know what they won't do? They won't deal with your application until you pay them. And if you go to court and say, well, wait a minute, I was allowed to apply, I applied, but they won't deal with it because I won't pay. And it doesn't say in the MGA I have to pay. It's going to go nowhere. Because the half of the MGA that you're not looking at, and I don't mean to say that disrespectfully, sir, is the fact that you have to administer what it says. You have to set up a system for filing an appeal with somebody. You have to set up an SDAB, hear it, and so forth and so on. That's not in the MGA. That's the power of the issuing authority as a municipality to set regulations for how to administer the system. And that goes right through everything. So like I said, I've just given you 3 examples. I could give you more. So just to say I'm just going to look at the MGA and nothing else would give you a very wrong idea of how things actually work in the system.
Is there a regulation under the MGA that provides any guidance on this?
Well, there's a bunch of them. Off the top of my head, appreciate that's what this is. There's sections right at the beginning of the act that talk about the powers of municipalities. I mentioned something called a natural person power. It means you can do what a person could do in any particular circumstance. You're allowed to do that. And you don't just have to have bylaws. You can have policies. This municipality has, I don't even know how many policies you have here. And they're applied all the time. And I don't want to lose sight of the fact in this discussion, sir, if I may, that the payment of a fee is a town of Kenmore policy. Okay? And you have to assume, as a board member, that that is properly and lawfully enacted. Even if I tell you that it is, you still have to apply it that way. So the question becomes one of, is it under the land use bylaw? 640 of the MGA talks about what you can put in a bylaw, you know, all kinds of things. There's an SDAB bylaw, you could put it in there if you wanted to. You could have a policy, like the city of Calgary does that. Sorry to mention that here, but it does. You rarely have a one-size-fits-all solution here, except for the fact that municipalities have the power to regulate 6, 7, and 8 by bylaw, resolution, or ordinary person powers. And the bylaws, sorry, and some of the planning stuff has clothes around it, if you will, in the MGA for what they're required to do and so forth. But it's like a land use bylaw. I'll use that as an example. You know, 640, which is a really long section, I think it's 640, says, here's all the things you can do. It doesn't tell you how to do them. It says, here's what you can do. You have to figure out as a municipality how to do them. That's part of your job. Same with this. It says, here's the requirements that you can't change. You've got to file an appeal in 21 days. Well, to whom do you file it? You'd never know that if you read the MGA, would you? You know, so this is all part and parcel of the administrative function that a planning agency has. And those sections I told you about, 6, 7, or 8, I'm sorry that I can't remember which one it is. 640 is another one. There's a bunch of others. But the point of it is, the MGA is like a skeleton, and the municipality is like the flesh and the veins. You know, so it has to give life to the structure. And if you don't give it the ability to do so, then the whole system is going to crash.
Thank you.
You're welcome. I mean, it's the best answer I can give you.
Any other questions from the board members? Nope, none for me either. Thank you very much.
And thank you very much
Council.
for your time and attention. Thank you. I'm concluded.
Madam Clerk, just checking in that there are no other parties speaking in opposition of the appeal.
Yes, that's correct. There is no one else.
Any correspondence either in favor or opposition?
No.
Board members, how are we feeling? Do we need a short recess to discuss, or can we move on to closing the hearing? All in favor of brief recess?
Brief recess.
All right, we'll take a brief recess. 5 minutes, enough time, Dawn?
Yep.
The hearing is now in recess. Madam Clerk, how will in-camera discussions take place with me absent?
Apologies, Peter, I couldn't hear you then. I believe you need to make a motion for the recess.
Okay, the board moves to recess for 5 minutes. All in favor? Motion passes. Recess for 5 minutes. Madam Clerk, are we prepared to proceed? All right, this essentially concludes the hearing. Does the administration have any closing remarks, comments, or clarification that they would like to add?
Yes, just give you 1 second.
Mr. Chair, I believe you need to make a motion to come out of the recess.
All right. Motion to conclude the recess and return to the hearing proper. All in favor? Motion passed unanimously. We'll proceed with the administration's comments whenever you're ready, sir.
Okay. Okay. So in conclusion, I have provided here 2 different slides that kind of provide a brief summary of the correspondence that took place between the appellants and the SDAB clerk surrounding the attempt to pay the appeal fee. These are just high-level summaries. The emails themselves are also contained within the package for this preliminary meeting. But as it's laid out here, on the 17th of November, the notice of appeal was received. It was provided after business hours on November 16th from the appellant. And so on the 17th, that was the first date of contact between from the SDAB clerk to the appellant, providing instructions on how to pay. And then from the 21st, an additional email was provided. On the 22nd, I've quoted the appellant in his response where he says he's going to call back later today to provide payment. That never happened. From the 29th, the town had deemed his appeal to be invalid. From that point, we received, or the SDAB clerk received a quick response to that email. Still no fee itself being paid, but rather just objections to the town's position. On the same day, the development permit was issued. On the 30th, the SDAB clerk reiterated that payment is required. More correspondence on the 30th, and finally a last ultimatum, if you will, on December 8th, saying if this matter is to be heard by the SDAB board, payment would need to be received, and payment being received on December 9th. So this is just kind of a high-level kind of description of the interactions between the 2 parties. I hope this provides a little bit of clarity in terms of the back and forth that a lot of this issue is predicated on. Is there any questions pertaining to this timeline I've laid out here in front of each of you?
Yeah, I just have one question. If we can just back up to the previous slide. So the decision was rendered on October 27th.
Correct.
And the 21-day period expired on November 17th.
Yes.
So if that was the end of the period, why would the clerk have sent an email on November 21st to extend the 21-day period?
Marcus, maybe you'd be better to address this question. Thank you.
So if I'm hearing you right, your question is, why did we reach out on
my question is if the 21 days is a hard deadline to file the notice of appeal and pay the fee, and there's no further flexibility, why would the town send an email 4 days after that and say, you can now pay?
Right. So to be clear on that, the original email on the 17th of November was sent out, with instructions to make a payment. And within that email itself, there was various methods you can use. One of which was to pay over the phone. So that was very clear in there. So once we sent the email on the 17th and we did not receive a response, we then followed up with the courtesy email to give them the benefit of the doubt and a fair opportunity to make the payment. And it was from there that we did not receive any further communication until the payment was actually received.
Okay.
So it was more of a courtesy than anything.
That's
Yeah.
fine. Thank you.
Nope. Well, thank you very much.
Okay. Sorry, if there's no further questions on those slides, I do have some other remarks I would like to make just for clarification, if that's okay. So one thing I will say, and Mr. Bardsley, actually summarized this quite well, but one of the things that we do here at the town, and it's a standard business practice, I'm across all application types, whether it's a building permit, a development permit, a planning application, we will not actually commence work on those until we have payment in hand. And that's standard across the board. There's also, some questions around, well, where does the fee actually come from? And Mr. Bardsley, again, had highlighted that at a very high level, that through the MGA, the municipality has the authority through council to establish fees for appeal boards, applications, and development authorities. And that's exactly what we've done. So when you look at this fee of, $250, that's actually within our master fee schedule. So it's a set fee determined by council, and then accordingly, what we've then done is included that information within our application appeal form. So it's in there, it's clear. When you file an appeal, it's the form, plus we also need that fee, because we are not going to schedule a meeting unless we had that fee, and that's why it's there. The other thing as well is that, this is not something that's out of the ordinary. We've been doing this with every application. This is a standard process. The fee's paid or we don't commence work. So this isn't, an exception to the rule that we're looking for here. This is a standard business practice. And finally, I would just like, to reiterate it again on what Mr. Bardsley had said around filing an appeal and the limitations that the board has, with extending those timelines. While it is quite limited, as you saw in our emails here, and we provided a bit of a grace period there, just out of a courtesy, from a good business practice, and we provided a courtesy there with a reminder email to make the payments. While you can, decide to say that, yes, we would accept the payment, we also need to consider around what is an acceptable, like a timeline to actually make the payment. Is, essentially an additional appeal period of 21 days acceptable? So I would like you guys to think about that as well, because this could also be carried forward on other applications if this were to happen again. And from administration's perspective, that is unacceptable. That's a fairly significant lag in between when the application was filed and when the payment was actually received, which is well outside the window of what the MGA requires. So on that note, that's the closing remarks from the town. And if you have any questions regarding any of that, I'm here to answer.
Thank you. I have no further questions, board members. No questions. All right. Does the appellant have any closing remarks, comments, or clarification? Mr. Clancy?
Yes, I do. Can you hear me or start my video? Okay.
We can hear you, yes.
Okay, good. Yeah, I think, a summary is probably in order here. Like number one, from my point of view, is the appeal was filed on time. There's been lots of discussion about, is the appeal subject and conditional on having the fee at the same time, 21-day rule issue. It's pretty clear that the town of Canmore doesn't look at that as a hard, fast date. It's not legally probably applicable, no matter what the Denton's lawyer would like us to believe. But there's not a correlation other than the policy, which is obviously not, it's not hard and fast. If it was hard and fast, somebody would have called me on the 17th after I asked them on the 16th to call me for the payment. Nobody made that phone call. They sent an email supposedly, which I saw when I pulled out the string on the 22nd of November. And so I did see that they sent it, but I never saw it, never got into my junk folder back then. Emails, as everybody knows, are not always most reliable. And so if something is that important, as I asked somebody to do, call me up and get my visa the next day, wasn't a hard thing to do. I gave my cell phone number and my office number, and my cell phone's always on. So if this was that important, then that phone call should have been made by the town of Canmore. Obviously, it wasn't that big of an issue. And for the second request on the 21st, I believe it was, and then on the 28th, they said it was invalid. That's why I didn't pay it on the 28th or 30th, contrary to what the city person is saying, that, I didn't pay it even by then. Well, they already said it was invalid. So what am I supposed to do? I sent a note saying why this was inappropriate, but, what am I supposed to do? Pay $250 just for fun? Makes no sense. So obviously somewhere along the line, somebody, I'm not sure it's the board or how it works exactly, somebody said this is something that, maybe we'll be willing to listen to the appeal of this. And so I paid the fee exactly when I heard that on December 9th. So I have had every intention of paying that $250, and from various administration things on the town of Canmore's part, and maybe on my part of me as well, it didn't get paid until December 9th. Now, I don't think Canmore City, is going to be hurting for $250. So, to have this whole appeal being thrown out because of this $250 thing, which doesn't have any basis probably in law. And number two, obviously policy isn't that stringent on this 21-day issue either. That I heard about, from the city and the Denton's lawyer, sorry, I forget his name, that they gave examples about, if you file an application, you have to have the fee at the same time. Well, you're doing a fee for a subdivision. Obviously, the person, the builder or developer, is not going to expect anybody to listen to their application unless the fee is paid when they make the application. That's a totally different concept. So make, to try and put that and correlate with this situation is totally nonsensical in my opinion. So basically, as far as I'm concerned, the application was filed on time in an appropriate form, which maybe, I guess there's a question on that, if the form is even necessary, but I did use the standard, website form and signed it and tried to pay the money by the 17th. And when nobody called, they figured no big deal. Somebody's going to ask me for it eventually. And that's how I thought of it, unfortunately. Otherwise we could have saved this whole afternoon of meetings. But anyways, so I guess to summarize, in my opinion, I filed it on time. The fact that everybody's trying to correlate this $250 payment to making this thing invalid because it wasn't paid within the 21 days. I think that's a red herring for whatever reason, and it's not a valid reason for this thing to not go forward. I feel sorry for the Harrises, they have to spend money today, and but you know, I'm not sure who's responsible for that, but you know, the appeal was filed validly, and that's the bottom line.
Thank you, Mr. Clancy. Does anyone have any questions for Mr. Clancy? Seeing none. Mr. Clancy, do you feel that you had a fair hearing today? Do you feel like you've had an opportunity to make your case and be heard?
Yeah, I think it's been a good discussion, and the board members had some very good questions and some valid concerns that they raised. And as far as fairness, I'll go with based on the results at the end of the day here, because if the results are not that this appeal goes forward, I wouldn't be thinking too highly of the whole process personally, but fair, it's probably been fair. I'll say that. Everybody tried their best, I think.
Thank you very much. With that, this hearing is now concluded. In accordance with the provincial legislation, the MGA, the board is required to hand down its decision within 15 days from today's date. So no decision is binding until the board issues its written decision. And that concludes this hearing this afternoon. Thank you, everyone, for participating. We will now move on to the second hearing. Apologize while I pull up the number. The second hearing is on file number PL 2022-0182, which is an appeal against an approval by the Canmore Development Authority for a mixed-use building containing warehouse space, retail space, and housing.
Apologies, Peter. I don't think we heard what you said then.
Oh, sorry, I was just introducing the second hearing, which is for file number PL 2022-0182. And I asked that the development officer for the town introduce the appeal with that number. As we do need to speak to or introduce the appellant and the applicant for the record, if you could just introduce the appeal, and we'll proceed to your presentation following those administrative steps.
Absolutely, Mr. Chair. So I'll just confirm that today's hearing meets all statutory requirements to hold the hearing today. A notice of decision was posted on site on November 18, 2022. Appeal was received within 21 days on December 8th. I believe we received a fee for that. A mail out occurred to alert all of the adjacent landowners of today's appeal hearing within 5 days notice. And the hearing date has been set within 30 days of receiving the notice of appeal as required by the MGA. So I can confirm that all the statutory requirements to hold today's hearing have been met.
Thank you very much. I'll now ask the appellant or their agent to identify themselves to the board, please.
I'm Melissa Yarmoy. I'm here with my I'm Melissa Yarmoy. I'm here with my colleague Rob Cooch, representing the property owner.
Thank you. Before you take off there, do you have any objection to any of the board members or the composition of this panel for the appeal?
No. None.
And have you received a copy of the agenda package which was distributed to the board? And do you have any objections to any of the information provided?
Go ahead. Go ahead. No.
No. All right. Thank you. That's all for now. Much appreciated.
Do you want me to talk?
Yes, if I can speak to the board first.
First, I'd like to thank the chair and the board and the associates.
Excuse me.
Sorry, before you move on there, we need to take care of a couple more administrative steps, and then I'll ask you for your presentation there.
So what was that?
I have some other administrative steps that need to be taken care of
okay.
before we can get your presentation.
Oh, okay, sorry.
Not a problem. This is the applicant's introduction and opportunity for objections. So I'll ask the applicant to, or their agent to identify themselves to the board, please.
Good afternoon. My name is Michelle Willette. I'm here on behalf of Spring Creek Mountain Village. Mr. Frank Kernick will be joining us by Zoom, and other members here on our team are Chun Man, who's a transportation engineer, Murray Freeman, who's designed the building. Sabrina and Jeff Durando are here with Castle Mountain Home Furnishings as well. And we provided a written submission to the board. That's in your packages. Thank you.
Thank you very much. I see Mr. Kernick is here as well on the video. Any objections to the board members that are hearing this appeal today? Ms. Willette?
Sorry, what's the question?
Do you have any objection to the board member hearing this appeal?
It's all good.
No?
Thank you.
Have you received a copy of the agenda package?
Yeah, we sure did.
Okay, and you're happy with the information that it contains?
Yes, we are.
All right, thank you very much. That's all for now. I'm going to talk through the hearing outline. It's the same process as the prior hearing. And we'll first make their presentation. Then the appellant will speak in favor of the appeal, followed by others speaking in favor of the appeal and any correspondence in favor of the appeal. Then those speaking in opposition, and correspondence in opposition. Finally, those speaking neither in favor nor in opposition to the appeal and any related correspondence. At any time, the board may ask for clarification by any of the persons speaking to the appeal. The board may then ask for a short recess if necessary. To close, administration will be asked if they wish to provide any clarification or closing remarks, followed by any clarification or closing remarks from the appellant. The board will then close the public portion of the hearing and go in camera to review all the information provided. The purpose of the hearing is for the appellant and affected parties to provide the board with information to the appeal. The board must base its decision on planning merits. As outlined a moment ago, all affected persons will be given an opportunity to speak. Please ensure that all comments are directed to the board. Also, we ask that all comments be of proper decorum and be succinct. If another person has already made a point, simply state that you agree with the point and continue. If any person presenting is referring to a written document, including a map, photographs, or a report, a copy of those documents must be left with the clerk. Does the appellant have any concerns with the process as outlined?
No, we don't.
Thank you. I'll now ask that the development officer make their presentation with respect to this appeal.
Good afternoon, members of the SDAB. Again, my name is Nathan Gravel. I'm a development planner for the town of Canmore, and I was the one who issued the decision on the application that's been appealed. I'll start with a brief overview of the application. The application proposes a 4-story mixed-use building with 1 unit of wholesale sales with accessory warehouse on the main floor, 21 units of common amenity housing, and 3 units of employee housing above the main floor. They're combined are 79 bedrooms between the two uses. 8 variances are required to the land use bylaw. Administration supported these variances as we determined these to have little impact on the adjacent parcels, and there are significant social and environmental trade-offs as part of the project. For example, geothermal heating and the type of residential use proposed. I thought it'd be important to highlight that the applicant, prior to proceeding with applying for a development permit, amended the Bow Valley Trail Area Redevelopment Plan and Land Use Bylaw to ensure the development concept had statutory support. The ARP amendments included adding common amenity housing as an example of an appropriate use within the general BVT precinct, as well as allowing for retail floor area bonuses in exchange for the provision of employee housing, common amenity housing, and vital housing, also known previously as perpetual affordable housing. And also, before getting into the details of the application, I wanted to touch base on common amenity housing as a use. It's a fairly new use. It's in our new land use bylaw. It wasn't in previous land use bylaws. The purpose of this use is really to encourage workers' housing through design rather than through regulating the user. So rather than stating in the definition of who can occupy it, you have design requirements that try to get to that outcome because it becomes a bit of an issue when you start regulating users rather than use from a land use perspective. So this definition is meant to respond to those concerns about regulating users, and it's, as I said, fairly new. It also means that these units are not explicitly limited to employees, although it can't be used as a tourist home that is a separate use. So it can be used sort of as a dwelling unit by anyone per se, but the way in which it's designed is meant to encourage the rental of it or the use of it by employees, if that's clear. So the design aspects include shared facilities, specific parking requirements identified through a parking study, which can help to tailor the development to its this intended use. Any questions on that before I move on? No? Okay. So just a bit of slight context for the board. The site fronts, as you can see up on the screen, onto Bow Valley Trail to the east, as well as Spring Creek Drive to the south. It is currently a vacant lot, and it's adjacent to a professional building to the north, visitor accommodation to the northeast, known as Skyline Peaks, under construction. Municipal-owned land, essentially a pathway, and also a large drainage lot to the east, vacant land to the south, and the rail line to the west. And here's a view of the streetscape in the summertime, because it doesn't look like that today, just to give a bit of a clearer view as you look down both directions of Bow Valley Trail. Looking at the land use map, the subject site and surrounding parcels are located within and at the midpoint of the Bow Valley Trail General Commercial District. So all the adjacent parcels share the same land use requirements. All the proposed uses are listed as discretionary uses. Here we see a rendering of the building looking from Bow Valley Trail. Again, it's a 4-story building. The design reflects mountain town architecture and overall meets the architectural and urban design requirements of the land use bylaw. The rendering doesn't actually include the landscaping plan here, so would look a little different on the frontage in terms of landscaping. Looking at the site plan, we see the footprint of the building is stepped back 9.62 meters from the front property line. There's a large landscaped area with a plaza along the front yard. 35 vehicle parking stalls are provided in the back and the side of the property. Vehicle access is from Spring Creek Drive. The main pedestrian access is from Bow Valley Trail. a secured accessory bicycle or accessory building with capacity for 40 bicycles, as well as short-term bicycle parking provided in the front and the back with a combined capacity for 36 bicycles is also on the site. So a number of, the appellant identified a number of concerns with the approval, 18 by my count, which generally fall into 6 categories as shown up on the slide there. So concerns about use, parking, architecture, landscaping, proximity to the railway, and intensity of the use. So I'll go through each one of these. If you have any questions as we go along, just feel free to stop me. So the first concern, we'll go in order here. So this is about the uses. The application does not meet the definition for common amenity housing, and the definition as follows. Common amenity housing means a building with separate sleeping facilities and common washing, sanitary, and kitchen facilities. So administration feels the development complies with this definition. All the floor plans here include separate sleeping facilities, common bathrooms, and kitchen facilities. And I'll show an example of a floor plan here for the 4-bedroom unit. You can see they're all separate sleeping facilities. All the bathrooms have common access to them. The kitchen is a common kitchen. So from our perspective, it meets the definition. Concern 2, no caveat was required to be registered on title to protect the uses and prevent a condominium from being created. This is not a requirement of the land use bylaw. Again, this requires regulating the user instead of the use, which, as I mentioned, the town is moving away from. And even with a caveat registered on title, there's no guarantee that that prevents any type of unintended use. It really forms a land use enforcement matter if somebody's using a unit in a different way from how it was approved. Looking at the third concern, no on-site management required to minimize parking, waste, or noise concerns. Again, management is not a requirement of the land use bylaw for these uses. The town is focused on the prevention of these things through design, not management. Management's very difficult for the town to enforce, especially if the property is sold to somebody else with a different vision for how it's managed. It's very difficult to get involved with that aspect. We leave that up to the landowner. We can say there's adequate on-site parking and waste facilities. There's a common patio provided on the second floor as common amenity space to really centralize socialization. It's a high-quality design, and it's screened from view and noise as it's surrounded by 3 sides of the building. There are no balconies, individual balconies for the units. Again, all the social activity is meant to take place on that second floor common amenity space. Looking at concern 4, and this is moving on to the parking concerns, the appellant indicated that increasing the maximum dwelling size and effectively increasing the number of bedrooms per unit will put an increased strain on parking. The land use bylaw requires that for common amenity housing, a parking study be undertaken to determine the precise parking needs for the site. This was completed by the applicant and submitted with their application. The study takes into account, obviously, these factors of how the common amenity housing is designed. The engineering team accepted the study, and the applicant has met the study's parking recommendations. Therefore, administration does not believe there's any variance here, and that these concerns are really just the opinions of the appellant. Concern 5 talked about parking studies for common amenity housing to be done at a future date. We weren't quite clear on what their issue was there, but they did say little room on the site to provide additional stalls if required. I mean, I think they'll be able to clarify that, but again, a parking study was completed as required. on-site parking complies with the parking study recommendations, so it's compliant. Concern 6, concern for change of use for the main floor commercial, which is providing 4 stalls for 1,339.8 square meters of, I assume, commercial space, whereas approximately 26 stalls would be required if used as a retail sales space. Section 2.7.1.2 of the LUB states a change of use application shall not require additional automobile parking stalls regardless of the proposed use. So the commercial units meet the parking requirements of the land use bylaw. It is true that no further parking would be required if the owner applied to change the use without any structural alterations to the building. However, it's not as simple as saying they would change it to retail sales. Retail sales is listed or restricted in the district to 150 square meters. So it's not like they could turn around and put in a large department store or something like that. And there is a limitation in the land use bylaw and also in the ARP. So they would need to actually amend the ARP if they wanted to put in a use that large that wasn't wholesale sales. Concern 7, the majority of the parking is visible from Bow Valley Trail, contrary to section 11.4.2.1 of the land use bylaw. Vehicle parking shall be located behind buildings, underground, or at the interior of the block, and that's obviously taken from the regulation that they're talking about, which is accurate. That is a general requirement in our section 11, which is the architectural and urban design requirements of the land use bylaw. However, in the district, which takes precedent over that section, regulation 4.6.7.1 states that all parking and loading areas not incorporated into the building or parking structure shall be visually screened with fencing or landscaping so as to screen it from view from the street to the satisfaction of the development authority. So there's a bit of a loosening of that regulation here for this district, and basically saying you can have some on the side or in other areas as long as it's screened, right? As long as it's not really visible. And administration was satisfied that the applicant had complied with this requirement, as the parking, which you can see up along the screen there on the left side, which I think is of issue here, is parking along the side of the property. It is set back 8 meters. It's limited in visual width. It makes up less than 10% of the width of the frontage there, and it is screened by landscaping. There will be a row of shrubs along the front. So it seems reasonable from our perspective that they've screened it, and it's not going to take away from Bow Valley Trail's aesthetic, if you will. Moving on to concern 8, site consideration, no on-site parking nearby, surrounded by Bow Valley Trail and the railway. Simply put, the BBTG district does not require off-site overflow parking, and as outlined, there is no parking variance. So there's no requirement or discussion about off-site parking or overflow parking. Moving on to concerns about architecture, the applicant stated that there is no corner feature as per standards with a corner lot development in section 11.5.1.6 of the land use bylaw, which is up on the screen there. And unfortunately, I'll read it to you. Buildings on corner sites must address all facing streets, adjacent buildings, as well as buildings on opposing corners. Buildings should acknowledge the special site condition by creating visual focal points at the corners, such as a circular bay window, a large dormer, a front entry porch facing the corner, or overall building form that faces the corner rather than one street in particular. Buildings should turn the corner. This can be further accomplished by continuing the same exterior materials and colors around the building to all street exposures, repeating window patterns on both sides, and continuing elements such as porches, roof overhangs, and balconies around the corner. So I'll pull up for the benefit of the board the corner here, essentially. So the two facades you're looking at, the one on the right is the Bow Valley Trail facade, the one on the left is the Spring Creek Drive facade. So the building continues the same exterior materials and color design around the building as it turns the corner. The window pattern is the same. The roof overhangs continue. They're not stopping, so to speak. It's turning the corner, if you will, which is the mandatory aspect of that regulation. The should portion is talking about, creating that viewpoint, if you will, at the corner and so on and so forth, but it is a should statement. And from administration's perspective, that's an option based on it being a should. So it's not mandatory. Concern 10, lack of steeply pitched roofs and distinct middle and top as per 11.5.3.5 of the land use bylaw. Building designs which divide the structure into a distinct base, middle, and top are required. Steeply pitched roofs with large overhangs, a transparent window middle section, complemented by a strong stone or masonry base, reflect traditional mountain design in Canmore. So the development has a distinct base. Maybe I'll just speak to it here. The development has a distinct base. You can see here with the use of stone. It has a distinct middle with the windows, and the top of the roof portion has steeply pitched eaves. So the pitch of the roof is predominantly 812, which is a steep pitch. There are some portions that are 412, but this is to accomplish a working roof design, which is encouraged in our urban design and architectural standards under regulation or standard 11.5.4, which I'll talk about in a couple of slides here. I'll show you some pictures of, but that's where they're implementing that other pitch. But for the most part, it's using a steep pitch, from what you can see. So in administration's opinion, the development complies with this regulation. Concern 11, variance on height and lack of stepping back the floors in context to the neighboring property, section 11.5.3.6 of the land use bylaw. Buildings, which they've included here, and I'll read again. Buildings should respond to their context by sensitively addressing the scale and massing of the adjacent buildings. This can be achieved by matching existing building heights or by stepping back the upper floors. Again, this is a should statement. So from administration's perspective, when we reviewed it, we determined compliance was not mandatory. So moving into some of the variances here, specifically the variance to allow for more dormer coverage on the roof with 15 and 20% open areas as shown on the approved plans instead of 30% is required. So the building is an additional 9.62 meters from the front property line. I'm not really highlighting this piece so much here. It was highlighted in the report that they did require a variance to the maximum front yard setback. The appellant hasn't highlighted that as a concern, so I'm not really covering it here, but they're farther back is the takeaway than what they normally would be required. So the requirement for a building is to be 2 meters from the front property line. So in this case, they're 9.62 meters back. So that's a substantial amount to be back from the front property line. And a lot of these aspects in the architectural and urban design standards deal with reducing massing, right, to the benefit of pedestrians along the street and so forth, opening up views, opening up lighting and so forth. The building's an extra 7 meters back. So I think there's some there's less concern about some of these pieces, and that's how administration looked at this variance, is that, if it was actually meeting the regulation there, it was actually 2 meters from the property line, there would probably be less views, less access to light and so forth than there is where it's currently situated with non-complying dormer mass. So that's on the Bow Valley Trail side. So there's two sides where this variance applies. There's the south-facing facade as well. In this case, the building's from the adjacent property to the south, it's 28.4 meters away. A dormer mass at this distance is thought to have really no meaningful impact on the property with respects to views, enjoyment, and privacy. Furthermore, the designer had indicated that to meet the dormer requirements would likely impact the number of bedrooms. They would have to remove some bedrooms to meet that, which would result in, so non-compliance from our perspective results in a public benefit. Okay, looking at concern 13. This one was the concern for the variance to maximum height. So the district actually permits a variance to maximum height, the BBTG district. It states where the development authority is satisfied that the architectural integrity of a building would be enhanced, variances may be granted to allow 20% of the building to exceed the maximum height by up to 20%. So the maximum 16 meters, so that's 3.2 meters in extra height they could potentially get. The development is within these parameters. It's actually under, I think it's 16.6 is what they're asking for in a height variance, and it's only for 15% of the building. That exceeds it. So in terms of the enhancement, right, because that's the other part of the discussion, or how you were supposed to get this, is how does it, the extra enhance the architecture. They are providing a working roof, which I'll show you a slide of here. The building on the left is a cut-off roof, so they basically got a flat roof, and then they've got these pitches down that make it look like it's a real roof, but it's not really a working roof. On the right, you're seeing what a real working roof looks like, and it's what you would think of as a roof, typically, right? And so there are advantages to this type of roof. It appears natural. The mass of the building is perceived as lower, and it's something that's encouraged in our urban design and architectural standards under section 11.5.4. So by them providing that, we felt that that was the enhancement, and therefore they could qualify for that variance. Concern 14, so this was concern for the variance to allow the building not to step back from the front building face for a minimum of 70% of the elevation. So as I touched on a little bit earlier, the objective of this regulation is to really step back the mass and open things up a bit as you go up with the building, which helps to, again, open up views for pedestrians along the streets, shadowing, things like that. The building is, as I mentioned, 9.62 meters back from the front property line. And again, the developer or the designer had said that to meaningfully comply with that standard, although the standard does not state how much they need to actually step back, it just says they need to step back. So if they were to meaningfully comply with that requirement, they would likely need to remove some bedrooms as well. And that, of course, the bedrooms here with the use are considered a public benefit. So moving on to concern 15, the variance to allow for an eave-line height of 13.4 meters. So the eave-line in question here, I'll bring it up, is located at the rear of the building around the common amenity space. It's perceived to have no material impact on any of the adjacent parcels. This is not visible. It provides some design flexibility with the upper units to ensure a more consistent ceiling height, which benefits those occupants as well. So given that it doesn't really have any impact on the adjacent parcels and there's some benefit for the quality of that type of housing, we supported that variance. Okay, concern 16, and we're moving on to site concerns, and we're almost at the finish line. Less than 10% of trees required are being provided, and in brackets they've provided the deficiency. 4 trees are provided when 47 are required. So there is a URW on the site that sort of wraps around a majority of the site. I'll bring it up here. You can see it highlighted predominantly in yellow. Some of the yellow does also represent the fire smart requirements of the land use bylaw, which states that you can't plant any trees within 1.5 meters of the building. So everything that's around the building there is essentially the fire smart, and then everything that's running along the property line, that is related to the URW. So you can't put the trees in the URW because the roots tend to rip any infrastructure up underneath. And it's also, there's an agreement registered or accompanying that URW that states they don't have the authority to put those trees in. So from administration's perspective, there's a site constraint there, and it really impedes their ability to provide those trees. Once you factor in the parking requirements, bicycle parking requirements and so forth, there really isn't much space left over for that. However, the applicant has provided a quality landscaping design, especially along the front. They've included a plaza with some seating, some bicycle parking, some different surface material, and they're also providing 133 extra shrubs. So they would only be required to provide 47 shrubs. It's the same ratio for trees and shrubs. They're providing 133 over and above the 47 that are required. So the short answer is we didn't really feel like there was a net loss, even if they weren't providing the trees. We felt like they were achieving the goal because they were providing good landscaping, which is going to contribute to the green canopy along Bow Valley Trail, if you will. Concern 17, concerns over railway proximity guidelines. When a substantial amount of residential and commercial is being built within 30 meters of the railway, the following applies, ... And they went on to highlight some sections of the MDP, which I'm not going to highlight here, but essentially the MDP says the town should have regard for the FCM's railway guidelines. However, in 2020, the town of Canmore engaged a consultant to perform a baseline risk assessment along the length of the CPR, really to understand the risk there and provide some guidance specific to Canmore as to when a railway risk study is actually required with some of this development. The FCM it's rail guidelines applies to, or it's a national document, right? It applies to all municipalities, or it's applicable, I should say, to all municipalities. It's not something we're obligated to follow. They are guidelines, but it's not tailored to Canmore. So we struggled with that, so we had our own study done, and this study basically says that the length of the building within the 30-meter rail proximity envelope is approximately 43 meters. The intended uses meet the definition of high density and low density occupancy, meaning 84 meters of the building length is permissible without a railway risk study. So the criteria that we have says they don't need a risk study. This is the short answer. Now, if they were to change the use and it was determined to be a sensitive use, then by all means, the town could ask for a railway risk study at that time as part of a change of use to something else. All right, this is the last one. My congratulations to all those who stuck it through. The intensity of the use as proposed will have significant negative impact on the safe and peaceful enjoyment of adjacent landowners. So that concern is quite broad, and it doesn't really speak to what the safety concerns are or what aspects of it is meant to impact the peaceful enjoyment. I mean, the appellant could speak a little bit more to that. Perhaps that was just sort of a closing statement, but nonetheless, from a land use perspective, there's no apparent safety risks. These are commercial and residential uses. These aren't industrial uses, so we don't view there as being any safety concerns. And as already outlined in the presentation, the approved variances in the opinion of administration do not impact the adjacent parcels. And we feel most of them actually contribute in some way a public benefit or meet the objective. And that concludes my presentation. Happy to take any questions the board has.
Thank you very much for that presentation. Board members, do you have any questions for the town? Seeing none, I have none.
I do. Could you go back to the slide in regard to roofs? The working roof and the architectural concerns regarding the roof line on your PowerPoint?
Yeah, it's coming up.
Okay.
There we go. This slide?
The one previous. You had it there.
So this is the one with the working roof?
Yeah, and previous to it, the bylaw regarding this one. There we go.
Okay, this one, the height.
Okay. I'm okay.
Okay.
Thank you.
Okay.
All right.
I have
If there are no-
another question, please.
Go ahead.
Can you show that, you said utility, I believe it's utility right-of-way? Can
Yes,
you
sir.
show that slide, please, again?
Oh, okay. Just a bit of a lag.
So what does that mean, cannot plant trees? Can you explain that to me?
Oh, so the yellow area represents the combination of the fire smart requirements of the land use bylaw, so essentially a zone free of landscaping from the facade of the building or footprint of the building and 1.5 meters out. And then it also represents the location of the utility right-of-way on the site. So if it's helpful, the utility right-of-way, if you can see my mouse, runs from here all the way up, all the way here, all the way down. So I'm not sure if that you can see it too well, but essentially it wraps around the site, and it's very wide in the front and along the north side or on the left-hand side of the picture that you see here. And it's not the landowner's URW, it's the utilities, and so they have a right to that land, and so the developer can't develop there or put certain things in there, whatever is permissible by the utility right-of-way agreement. Typically, utility right-of-way agreements don't allow for things like putting a building there or putting trees. You don't want to have a building there in case you need to get access to it, rip it up, do maintenance to it. You don't want to plant trees there because the roots of trees can go down into the soil, and if you've got lines, water lines, things like that, they can break them. So we view this as a site constraint that prevents them from putting trees in this yellow area. The rest of the area that you see is predominantly for parking, bicycle and vehicle parking, pathways, so there's not much left over for them to put trees.
So that on the left-hand side, is that the drainage you was referring to?
So that's right here.
Yeah.
So that is a drainage right-of-way. This utility right-of-way is one right-of-way, from my understanding, and it includes a number of different types of infrastructure. So this is drainage along the side here, where the heck's my mouse? Basically on the left-hand side of the screen, and then along the front you've got a water line, and I think you've got a gas line in there as well.
So would there be an option to move it to somewhere else?
The drainage, I wouldn't be able to speak to that. I'd have to defer that to, well, I could speak to it at a high level in that somebody else has a right to that land, right? That's out of the developer's control. So this was, provided a while ago. It wasn't just provided. It wasn't provided when the developer purchased the land. And so they have an interest in this land, that owner. And it's basically at their discretion whether or not they want to, whether it's the gas line and so forth, whether or not they want to shift that. Some of it might be ours, so I would defer that question to our municipal engineer. But if Brian is with us. Oh, he's actually here. Okay, I thought we were going to have him zoom. I didn't have to go on for so long.
Yeah, so running adjacent to the site between 500 and 502 Bow Valley Trail, there are 3 underground culverts. And those are meant as an emergency flow route because just off the screen on the other side of Bow Valley Trail is a stormwater management facility. And we need those 3 culverts to convey an emergency flow which would go to the railway tracks, which would then eventually find its way to overland water courses. So those triple culverts there, at first glance, I don't see another viable alternative to location for those. For the URW that runs from the left to the right of the screen, at the top of the screen, we do have a large 300 mil water main in that, which occupies the portion of the utility right-of-way closest to the building. There may be an opportunity to relocate some of that. It would come at significant expense to do so. And I'd have to look at what the other constraints are there. There are also a number of shallow utilities in that URW, including gas, fiber optic, and electric.
Thank you.
Any further questions from the board? No? All right. Thank you very much for that presentation. We'll move on to the appellant's presentation.
Oh, we can use that, okay, for... You can, yeah, if you need to. Yeah, okay. Yeah, I'll just get started first. Thank you. Yeah, so you can just turn, and not quite yet. First, I just wanted to, now it's my turn to speak. I need to apologize in advance for something that I'm hearing challenged, and I have trouble with Zoom. So earlier on, and I don't have the proper aids with me, I read lips. So I just wanted to let you know that a little bit. And not that that's a challenge for what we're trying to do here, but it's important because with Zoom, I had trouble hearing you because the voice was after. So we're through that. So back to where I started, I just wanted to thank the chair, the board, and the associates for allowing me to speak on behalf of the appeal and the appellant. And just to get started, I wanted to make it clear that it's not about the results of this appeal, it's about protecting the interests of our adjacent property, 400 Bow Valley Trail, and basically receiving the same consideration from this, the effect of this development. Not the same allowances, but the same consideration of the effect that this development is going to have on their neighborhood. And I started with the development drivers. And for the development like this, my background tells me it's about 3 separate items. It's about the people that are going to be living there, in cooperation with the mixed use, about the commercial that's there. It's about the building, and the third is about the traffic. And those are the design drivers that we look at during what I call origination phase, and that's my background. My name is Rob Cooch, and I'm here representing my good friend Ruth Rance, who's the owner of the property. And my background includes I'm trying to retire, but my background includes decades of work for nonprofit organizations, charitable organizations, design efficiencies, land acquisition, and basically origination phase development. Does the land work within the parameters of the development needs? Does the development work in parameters with the land that we're looking at? All of that wisdom has been gained basically in British Columbia. It's a fancy title that basically says, I go in there and I try to see if this is the right fit, this building for this property, or this property for this building, and if that works within the community's, within the community's site or official community plan. And I'm familiar with these properties because I was asked to come out a couple of years ago and take a look at 400 Bow Valley Trail and 500 Bow Valley Trail. I worked well with Matt Delaney, and we tried to take a look at, basically establishing a building envelope. What can happen with these properties? What's a good use? How does it fit with the Canmore plan? My background is in Kelowna mostly. This isn't Kelowna. This isn't British Columbia. Every property and every building has its own character and its own importance. I need to make a disclaimer. The professionals that are involved in this, the engineering, the architecture, everybody that's taking a look at it, are professionals and doing a good job. When I start hearing engineers using the words rationale, assumptions, conclusions, predictions, when I start hearing the words of politicians quoting bylaws or policy or design, I get concerned. Because to me, engineering is analytical, it's about data. And parking, in this situation, there's a lack of data. We're jumping around from different definitions. There's new definitions, there's new zones. For a simple timeline, on February 3rd, the DP had its origination, typically the phase where I start on a project. And on April the 5th, the engineering did a preliminary report from Matt Delaney, which I had a chance to go through this week. On December the 8th, Melissa submitted the 18-point concerns and the appeal. On January the 1st, I got a call that, hey, Rob, I need your help because I don't speak well in front of people. I'm very concerned about what's happening on my mom's old lot. And I've gone through a bunch of the bylaws, and there's a bunch of things that don't make sense. My original reaction was, I'm not your guy. I'm not familiar with what's going on. I'm very comfortable in these situations. I'm comfortable talking to people. I can speak engineering. I can speak design. I can speak about traffic flow, and I'm comfortable with that. But I'm not familiar with this property and this development specific. But I'll come out and help you. And so I came out, and the more I looked into it, the more I realized that there was basically, with this new zones and new definitions, there was a lot of bylaw, there was a lot of guidelines that weren't available. If we were operating in the same land bylaw from a year ago, we wouldn't be building within 30 meters of the rail. We would be looking at needing a bunch of parking. We'd be looking at needing, a bunch of landscaping. And nicely stick-handled through all the policies. We could never go head-to-head with the policies. There's always a way out. And I said to Melissa, first of all, let's ask you not to pass judgment on basically the appeal. So what is your desire as the appeal? We need to have that clear to the board. Well, it's not to stop a development. It's certainly not to stop common amenity housing. As a matter of fact, we support that. And it's not, as a matter of fact, to even stop, from having the furniture store, Castle Mountain, in there. What it is to recognize that the process is so new that it's flawed. And that coming up with those parking numbers, absolutely you can. But the real intent, and I'll get to it in a bit when I get more detailed, but you need to be careful what you ask for. Canmore has very few common amenity housing projects. This is new to Canmore. Canmore is very high-end. Canmore is a beautiful city. I need to recognize also that the Spring Creek development is world-class. The developer is not in question. It's this specific development, and it's the fit of this specific building, and it's the bulging factor that you get when you overdevelop a piece of property. It's the fact that you can't plant trees. You have to take them out. Yeah, the building meets the right height, but it's on the corner, and it's going to be a very prominent corner. So architecturally, absolutely, it's got stone on the bottom. And it's got a mansard roof. That isn't the question. Melissa went through that very specifically, and there's specific bylaws. The bylaws and those concerns, those architectural concerns, are there for a reason. And this town of Canmore put them in there for very good reasons. By changing the zoning or the land use bylaw to go and say, okay, we're going to add a warehousing, or we're going to add common amenity housing, or we're going to add staff housing. Well, that supersedes the ability to say you need this much parking. Or it supersedes the ability to say your setback can be this far and not that far. And if I had time, I'd go through all the specifics of it, but I would never want to go head to head. You've got a great staff here. When you do a design such as this, you usually design anything to its maximum occupancy. What is its greatest build-out? What's going to happen at its greatest build-out? So when I started going through, and Melissa's highlighted, we've got some documents that, in addendum that you'll get. When I started going through the bylaws and the parking and things, it was very convenient to say this is, where have I got it here? This is 24 bedrooms. Well, there happens to be 8 beds in each bedroom. These are 4-bedroom units. There's 8 people living there. There's the common amenity spaces are not sufficient for the living of for a lifestyle. And then I got through the logistics of the moving around. I'll get to that in a minute. I want to just go, so what is our goals? We're trying to protect 400 Bow Valley Trail. Why have we called you here? Why are we appealing this development? And again, I reiterate, it's not because we do not want common amenity housing. Maybe the definition of it and maybe the interpretation of it is maybe what we're after, some clarity there. It's about the 3 things. So people, are these attainable rental units? Is it privacy with a common amenity? The second thing, the building, functionality, lifestyle, the flow. The definition between wholesale and retail, I struggled with in your bylaws. And in some of the reports, the word retail popped out sometimes, the word wholesale popped out sometimes, wholesale sales popped out. There was definitions and there was uses. And the intent of the bylaw is, I think, what's being breached here. It's the intent of the parking. And like I said earlier, you've got to be careful what you ask for, because if you're a furniture store and you get this 0 parking, or you have 5 stalls that are assigned to you, and you don't have a place that a customer can come up and pull up and visit, maybe it's not a win. Or when you're loading dock, when you take a look at the picture of the loading dock, I went, okay, when there was access through Bow Valley Trail, it made sense. When you came in off of Spring Creek, and then you came to and you could back in a 53-footer or a cube van or something, okay. And that was in the original proposal with the rezoning, by the way. There was access to Bow Valley Trail. There's been a design reiteration, and there's been design changes all along. So again, January 1st, I started taking a look at this, and I didn't know how I could help. But I realized that there's a bunch of inconsistencies, and there's a bunch of assumptions. Okay. The 3 points again were the people, the building, and the traffic. So you take a look at the people, it's the workers. We're looking at supplying for workers, right? And which are the very fabric of the commercial business in Canmore. It's a huge problem. Understand that. It's a huge problem in Kelowna. It's a huge problem everywhere. How do we house these workers? And then our goal, probably similar to yours, is common amenity is bedroom privacy at a low cost. Low cost is a two-factored thing. Low cost to deliver the product, a low cost to the developer, so he doesn't have to get over expensive with delivering the product, so that there's low cost to rent accommodations. I'm sure it's similar. Management of the rentals becomes an important issue, because direct control management puts it into a rental pool, so those rentals are available to everyone around. In Kelowna, we're very distinct about the difference between common amenity, staff housing. There's a difference. Staff housing, you're supplying for the benefit of your business. Common amenity, you're supplying an affordable rental solution. I couldn't understand exactly where we were heading with this, and it's been a short time for me to wrap around, but I agree with Melissa that there isn't clarity in this development on that. Common amenities. Design drivers are basically, you have a private space. You respect that person, that worker. You have a private space to go to, like your bedroom. You're not sharing it with somebody, but you don't mind sharing the kitchen. You don't mind sharing, the shower, and you don't mind sharing the social common room. It doesn't mean lesser of an amenity. It doesn't mean a smaller space. It means a shared space. And this building, when I walked through, and no slight to the architect, because I bet you anything this building's been built somewhere else before. That's the way architecture works, or a similar model. Was it used for common amenity? I don't know. But when you do a flow through this thing, and when you take a look at it, you have a closet, you're sharing a bedroom, you've got a locker downstairs, probably 18 by 18, it looks like, it's not scaled out. You have a small locker in the basement, down the elevator or downstairs. You got bike storage down the elevator or down the stairs in the basement. And you're sharing a closet with potentially eight people. Again, when you design to maximum occupancy. Yes, there are going to be 8 people. Their rationale, and a lot of this information is no. It's when the parking, well, it's not going to be full. We're going to share the parking. They're going to drive to work and during the day. I keep hearing all these assumptions. Common amenity versus employee housing are two different things, and it's not clear which one of these is. The second component that I thought I wanted to get my head wrapped around was the building. So we have wholesale, warehouse classifications, retail, bulk goods, a bunch of definitions that basically drive a 0 parking lot requirement, a maximum of 10, from what I could read. There was a Class C, a Class D. Melissa's got it all highlighted for you. But when I went through it, and again, like I say, you follow these rules and regulations, and that's fine. But what is the intent? What is the intent of the warehouse? What is the intent of the building, of the furniture store? To have no parking stalls or have complicated parking? And it doesn't matter to 400 Bow Valley Trail. But what it does matter to 400 Bow Valley Trail is there's going to be a parking problem. There's going to be a flow of traffic problem. I can say that in confidence. How we can manage our way through the, stick handle through some of this, the bylaws, and say that we don't need that parking, or we don't need another access, or we don't even need a hammerhead turnaround, or our loading bay can interfere with the residents' parking, how we can say that through code or through bylaw or through these changed zoning land use is not the argument. The argument is the end use. When you take a look at building design, you look at dorms, or you look at common amenity, you look at University of Calgary. I mean, this design, this architecture it's basically a strata. It's a everyday 4-bedroom, and we're adding a couple of bathrooms. We're eliminating a dishwasher. We're throwing a bunch of small fridges in. The amenity space, the living room, well, it doesn't matter. You go to each floor. On the second floor, there's a big patio space. To get to that patio space, you have to go through 2 doors through a lounge. There's no secondary exit out of the space. Yeah, there's a 1.8 meter or whatever fire or sound attenuation. But you're sharing that space with 158 people. Worst case scenario. A dorm living is not terrible living, but it respects the very first thing for people. It gives you privacy in a bedroom and shared amenity, not less, but shared amenity. I'm not saying this design is offside on that, but I'm saying that, in my opinion, that building doesn't fit that lot. That's overbuilt. You got these 1 bedrooms where it could be common amenity. I'm not here to question that. I'm not here to talk about that. I'm here to talk about the impact on 400 Bow Valley Trail and having 158 people with basically 30 parking stalls and not enough bicycle and circulation traffic. The third component I wanted to talk about that we always look at is traffic. Canmore taught me some very good lessons. Traffic isn't about cars, not just cars. Traffic is about emergency vehicles, fire, ambulance. It's about bicycles. It's about walkers, strollers. It's about electrical. I don't see electrical charging station here. It's about pedestrian, and it's about vehicles. The traffic also inside a building. You always look at traffic flow inside a building. It's a part of architecture. If you live on the third floor around the corner, I'm not comfortable with a building that has an elevator that's situated on the backside of one wing. It's more a central core thing. But again, you guys build the building you want to build. But there's going to be disconcern and there's going to be discontent of those people living there, because it's very difficult traffic flow inside the building. It's clumsy to me. But traffic flow outside is a process of engineering. What we received and what I could find was a parking study, not a traffic impact study for the neighborhood. Correct me if I'm wrong, but I don't think there was a traffic impact study done. And this is close to, like Melissa says, it's close to the train tracks. I took a drive down, I'm very impressed, by the way, with the Silver Creek developments, beautiful buildings. And nice little high end. And I took a drive down there, and I had to stop because there was some construction truck, and then the snow was piled up with the bollards, and I went, well, it's kind of clumsy through here. What happens with the big bus and stuff? And it's all fine, and Canmore's approved it. And I got through and I went, I like that log building, and that, I'd like to stop there, but I can't. There's nowhere to stop. There's a couple pullouts and then go through, and I end up coming through to the other intersection from Silver Creek. So the intersection at Bow Valley Trail, and I'm not saying anything, everybody here in this room knows this, but the intersection of Bow Valley Trail is the second for all of that development, the extra 1,000 rooms that are going in there and the extra traffic and all of that capacity that's going in there. This building at 500 Bow Valley Trail is affecting what happens to us at 400 Bow Valley Trail, and we would like to ask and see a traffic impact study done that is realistic and uses some guidelines as third party, that isn't a part of the development team, that actually takes and uses, some proper data. When it came down to the data of the parking, the parking study, one thing jumped out at me, that they went to a different building, and the manager of that building had said something about only 10% of our people that live here have vehicles. So, okay. But to use that statement that isn't proven data in a parking analysis for a building, it doesn't make sense to me, because there isn't the data, there isn't the bylaw, or there isn't any regulation tied to these new zoning, tied to this common amenity, or you have a different word for it. There isn't anything that they're following. There's a bunch of unknown there. There's a bunch of assumption there. Like I said, engineering and assumption, they don't often collide in the same sentence. But here they do. Here they do. So we got 24 residential units. We got 79 bedrooms. We have 158 beds. Conveniently, some of the bylaw parking, we use, how many units do you have in the building? Well, 24. Okay, so we need this much parking. Conveniently, we use how many bedrooms for other analysis. But I don't see anywhere in here where we use a maximum load occupancy of 158 people for any type of impact. And that's another thing that jumped out at me, was that we conveniently use the best solution if the driver of developing this property is that building, and we start changing zoning and applications. We get past 2 or 3 variances in Kelowna. We get past that 2 or 3, we just go, whoa, we better take a look at this. How many are we up to? Is it 8? 8 variances that the developer has asked for? So 8 variances from the existing structured bylaws that have been changed and relaxed. Those are the things that jumped out at me. I usually have a PowerPoint. I usually go through and cite some nice bylaw. Sorry, I'm not prepared. I do not have that with me. We have an awful lot of information from Melissa. Melissa is more comfortable as a barista than speaking in public, as she should be. But as a business owner and as her mom having 400 Bow Valley Trail, it was important that I tried to interpret their concerns to you. People, lifestyle. Are we giving these workers the amenities that they need? Are we giving them an opportunity for respect and privacy? Are we giving them a design that is working for a common amenity? Are we designing this building for the workforce? Is the workforce a different class of people that we don't need to address some of the amenity needs of them? That's our question. So the design component is on the amenity side. Is this overbuilt? Is this building pushing the envelope of lifestyle and respect? The building itself, the variances worry me. The building is, you can go ahead and build the building. But the synergy of the site to the building is a concern. The use of space is a concern. You know, the hard packed surface on this building is incredible. That's why you can't plant trees. You know, you've got parking everywhere. There's no extra parking. There's no on-street parking, but you don't need it. You know, if you've got 30 stalls for 150 people plus, or 5, I think it is, for the warehouse, maybe technically you don't need that. But we would like to see a traffic impact study. That's important. We'd like to see, you know, basically a loading study. I think that for the benefit of the furniture store, some type of study that involves, you know, the movement of vehicles on this site. Take a closer look at the plan. In your mind, drive through there. Back a big truck into that loading bay. Bring your bicycle and see where you have to park it. There's a bunch of stuff that doesn't work. So, Melissa's come up.
I think Rob's done a great job of just an overview of our concerns and.
Go ahead. Speak in here.
If we can get this on, just an overview just of the parking. We had a couple issues with the McElhaney parking report. They made reference to a letter from a Banff operator. I found the original. It's from Stephen Birch, and it does a 10 to 15%. And we would just like the board to also consider the Kananaskis Way, 120, 130, when they're looking at parking considerations. It's really unclear, but for common amenity housing, it does make provision that a parking study is done and a traffic impact study. And our questions with the McElhaney study, they refer to the peaks in their study. We just did a very quick Google review of the peaks. They've got 20 negative reviews, 8 of them cite parking specifically. And yeah, I think we've taken up enough of your time and really think.
Are you okay?
Yeah.
Yeah. Yeah.
Yeah. So.
And in addendum, everything that Melissa's done, we've put a package together for you for your review. And it's highlighting some of the changes that in those zoning and those bylaws. Clearly, in the short period of time that I've had to get involved in this, it jumped out as, you know, this is a type of development permit that doesn't need to disappear, but maybe it needs a review. Maybe it's best for the town of Canmore to consider some of their intent on the rezoning changes. Okay?
Yep.
Thank you.
Thank you very much. Just stick around. We might have some questions for you up at the podium there.
We're here.
Board members, does anyone have any questions for the appellant?
May I have the opportunity to speak to the board?
Go ahead.
I think
If there are no questions for the appellant, I'll ask for others speaking in favor. It sounds like someone there is looking to speak in favor of the appeal.
Sorry, Peter, could I just interrupt briefly? Could we have a 5-minute bathroom break, please?
Absolutely. The board moves for a 5-minute bathroom break.
Thank you.
5-minute recess. Everyone in favor? All right. Motion passes unanimously. See you at 5:10. Is everyone here who needs to be here, Madam Clerk?
Sorry, Peter, I didn't hear what you said then.
Is everyone here who needs to be here?
Yep, everyone's here. Thank you.
All right, the board moves to return from recess. All in favor? Motion passes. Does the board have any questions for the appellant with respect to their presentation? No, seeing none, I'll now ask any other people speaking in favor of the appeal to come forward, give their name, and to make their presentation.
I'd like to introduce myself to the board. My name is Shane Yarmaloy. I don't have a financial interest in the adjacent properties, and I would like to, believe you have a letter from Frank Kernick there, which is incorrect. The fact of the matter is I reside in Banff and not in the Shuswap. And there was some other reference there as well. It's, I believe that this development permit application was improperly heard. Years ago, I sat on the downtown and highway commercial architecture committee, and this in fact no way complies this development. I realize that to any of those, even architecture controls back then, the application should have been heard under a direct control application, should have never been approved by the Planning Commission. It would be, you know, this application would come under your jurisdiction. And, you know, I have a couple of recommendations. I think an underground parkade would be a great solution to the parking problem there, but that's entirely up to this board. So thank you very much.
Thank you, sir. Does anyone have any questions for Mr. Yarmaloy?
When you say this should have been done by way of a direct control application, can you just elaborate on that?
Well, a direct control application would allow you to relax all these requirements, perhaps even go even another floor higher. But it also would give that project the insurance that it wouldn't be condominiumized and sold off. So yeah, there's too many variances that have been inappropriately granted by the Planning Commission, and this should have come directly to the DAB. So in, you know, direct control, I think we've got a few of them. I think 120 Kananaskis and 130 Kananaskis Way are under direct control and are similar type use. So I'd encourage the board to look at the, you know, on that development permit, how that proceeded to go ahead. Fortunately, Frank is by far one of the best developers in this community, and his product is second to none. So it's no question of that. It's just I think it's the wrong building for the, you know, for the wrong site, right? I think the furniture store is a fantastic location. I do like the fact that you know, that the town is starting to consider bigger retail operations on the highway commercial lands for Bow Valley Trail. So, you know, it's an interesting proposal. I would like if if the board took a strong look at this and give it some consideration. Thank you.
Anything further for Mr. Yarmaloy? No. All right. We will move on to any correspondence in favor of the appeal, Madam Clerk?
We did receive one email from an Edwin Scotchilas, which can be found in the agenda package.
All right, would you please read that into the minutes, Madam Clerk?
I'm afraid I don't have it in front of me. I can read it if you like.
If you could, that would be fantastic. I would appreciate that.
It is in the agenda package. Bear with me, I just have to pull it up.
Excuse me, Mr. Chair. This is Lauren Miller, the Manager of Planning and Development. Just as a point of order, we don't typically read the correspondence in verbatim into the record if it's included in the agenda package. But if you particularly want it read, we can definitely do that, but just wanted to note that as a procedural item.
Yes, thank you for the input. I'm just reading off of the procedure directions. I'll leave it in your hands as to whether or not we proceed to read it into the minutes. But if it's in the agenda package and you feel that it's not necessary, then we don't need to do that. It's available on the public record.
I'll just leave it with you in the agenda package. Thank you.
All right, thank you very much. I'll now ask those speaking in opposition to the appeal to please come forward, give their name and make their presentation.
Hello again. I'm going to be running the slides on behalf of Mr. Kernick. And I just wanted to address one thing. First of all, my name is Michelle Ouellette. I'm a professional land use planner. It's the work I do. Previously, there was some discussion about a direct control district. Now, last May, as you'll see in my written report, that Council made a decision to make the changes to the district BVT-G and amend the area redevelopment plan. There was discussion way back in that process about use of a direct control district, but it wasn't preferable because this opened up an opportunity for other businesses on Bow Valley Trail to support the initiative of having employee housing offered in exchange for some, development rights and those types of things. It was a town benefit that we did it that way.
Can you guys hear me?
Yes, Mr. Kernick.
Thank you. So Chair and the rest of the Subdivision Development Appeal Board, my name is Frank Kernick, the developer, one of the developers on this piece of land at 500 Bow Valley Trail. As you heard earlier, I'm also the developer of Spring Creek, previously Eagle Terrace and Canyon Close and Guatemala Village in Canmore. You probably know the reason why I've at least a little history on why I'm involved in this project. Jeff and Sabrina that own Castlemont and Fernchine approached me a couple of years ago looking to move out of their space that they're in right now, or at least expanding from the space they're right now to owning their own commercial space instead of paying the lease fee that they pay right now to the current owner that they probably paid off his mortgage 3 or 4 times and have their own space and long-term tenants. And they can talk more about that in the future. They were the ones that recommended this parcel. They were the ones that I know negotiated with Shane's ex-wife Ruth and Melissa's mother to purchase this parcel. And I said if they were able to acquire this parcel, I would consider being a partner with them on the parcel because they thought I wanted to build condominiums. And I said, no, I really need staff housing. Spring Creek used to be a restaurant trail park and cabins owned by my father and my uncle, and at one time had 220 mobile homes and 300 campsites. We're again near the end of Spring Creek when I bought out the family in 2002. My area redevelopment plan was approved in 2004, and we started construction in 2006. I always knew that the hotels that are going to build there I also built my seniors housing building, Origin at Spring Creek there, and also some of the construction staff that I have there. We always needed some form of staff housing. We have been using mobile homes or old trailers in the trailer park for the past number of years to house all our staff, but we're getting to the point that we only have a couple years left. And so the timing worked out really well on this. It's a little tight. We were really hoping to be in the ground last year, but with all the changes we had to do to zone these lands to create staff housing, because I have right now approximately about 80 or 90, I think it's about 60, 90 staff, depends on peak low season, in staff housing. We know with 2 future hotels that I will be doing, we'll be up around the 100, 120 staff in I'll need in staff housing. Same as Banff Springs, same as the Caribou property guys in Banff. There's anyone that's been in the hotel industry or anyone in the hospitality industry knows in Canmore or Banff that if you don't have staff housing, you will not get staff. I have no intent, and there is no intent that there'll be these 4 will be one title. The first 4 will be turned over to Jeff and Sabrina. They'll be buying that off me, and the other 3 floors will be owned by my own staff housing company to make sure that I have staff housing or I will not have staff. We did look at direct controls, Michelle said. That was our first proposal to the town. And we did ask, through Sabrina, asked Ruth, Shane's ex-wife, if they want to be part of that area in that zone. And we actually had them incorporated in our direct control zone at the time because we weren't taking anything away from the district. We were given additional opportunities for use in the district. So if anything, what we've done for all Bow Valley Trail is we've allowed for the increase in value of land, not to decrease the value of land, because now there's more uses, not less uses. And that is allowed by allowing for anyone on Bow Valley Trail to be able to do common many housing, perpetual affordable housing, or staff housing, and also be able to do warehouse, wholesale sales of warehouse housing, which was not allowed anywhere except where they're currently allowed right now, and maybe one small area in Three Sisters. So there's no opportunity for Jeff and Sabrina to grow their business except where they were right now. And this allowed and was an thought, I think, of the town of Canmore. And it was really a time needed for Bow Valley Trail District to be really looked at for these opportunities for growth, for affordable housing, for the community, for the people that live in the community, for the workers that we need in the community, and also for some businesses to stay in the community. It'd be a huge loss if we lost Jeff and Sabrina in business Castle Mountain Home Furnishing that's been in the town for over 30 years. And so this was something that we looked at the last couple of years. It took us over 2 years, 4 open houses we had, and the young ones are totally welcome to participate in those open houses. We told them about it. We also had a public hearing with the town of Canmore when they did rezoning of the bylaw to do Bow Valley Trail, which again, they were welcome to participate in and give any concerns at that time if they had with parking or anything like that. And so we've had lots of opportunity for input. And then this is just the part that, that I understand that everyone has concerns when the adjacent neighbor that, as people could be parking on my property, this, that stuff. It is their private property. As I have private property, I'm welcome to put up no parking signs. I'm welcome to get them towed off my site. And I understand that a couple of the small concerns like that. Traffic, I know they brought up. We've done so many traffic impact studies. We have a counter, matter of fact, on the road right in front of their property that we do with the town of Canmore every year. We do we just did another one here last year, a traffic impact study. That road's designed for over 10,000 vehicle trips a day. And you can ask, I think Andy might be the town of Canmore engineer on this as well. And I think Max will do 6,000 vehicle trips a day. I've never waited more than roundabout than 10 seconds to go around out of that road. Not like sorry, Andy, not to hang you here, but not the Bow Valley Trail Railway Avenue intersection. That's a different story. I didn't design that one. Not throwing you under the bus, Andy. But I have a hard time understanding really how 400 Bow Valley Trail, the land adjacent to B, is affected. Shane, who talked there today, I did rent the land off him and his ex-wife Ruth, and he talked about cutting down trees. Well, he begged me to cut down probably 200 trees off that property when I rented the land off him to store my gravel. We are doing everything we can to save the trees that are on site, and I'll go over that on our landscape plan in a minute, the few that we do have. It is a utility right away in front of us that is for the benefit of the town of Canmore, both for storm and the water line that runs through there. And that we can only get a building up to 9 meters because the water line is not in the middle of the right of way, is really close to our building foundation. So we had to push our building back an extra meter, even just to make sure that if they ever had to dig up the water line, we weren't affecting the opportunity then for excavate that and affect our foundation. So just with that, we have reported a report through Matt Delaney that was attached, and as you should have hopefully read that, my team is here to answer any questions that you may have on that. I'm not going to go in great detail about the report, but I will get Michelle to put up just a first slide real quickly, just to maybe just highlight a few of the areas of concern. Again, if you do know Spring Creek, we are a leader in built green. We are the first built green community.
Sorry, just to interrupt. Unfortunately, when we switch to presentation mode, we can't hear the person on Zoom. So we just need to figure that out technically. And we will, yeah. So if we could just pause a moment, that would be great.
Frank, can you just say something? Okay, I can see you talking on the screen, but we can't hear you.
I can try and go on Zoom.
Frank, could you share, do you have this presentation?
No,
No,
I
you
don't. Sorry.
Okay. We were going to say maybe if you share your screen, that would be able, we can't share it from, we can't share from our location.
I am just going on my phone to join Zoom as well.
Oh, okay. No.
If you can join me in on the meeting on my phone.
No. If you were on your laptop, let's say, you could share your screen and that would show up, but we're having technical difficulty with the presentation here and you speaking.
You know, we don't need the visuals. I'm fine without. I can talk around the visuals real quickly. You do have most of the visuals there, so if you can hear me, I'm fine talking without them. I think this is just best get brief. So if we can do this quickly without the visuals, I'm fine without the visuals. I'll just talk around them. Are you okay with me continuing?
Please go ahead.
Okay, thank you again, the chair and SDAB members. You will see in our package some elevations showing our building. The one you have is a little bit older. We do have a revised elevation that Michelle, if you want, she can put up later. It just really shows that we changed to more timber on the commercial entrance the town asked us to do with Core-10 metal that you see on the Malcolm Hotel. That is a variance because metal was not allowed in the bylaw because it's outdated. But Core-10 is a beautiful metal. It rusts and has a rust look, just like the Malcolm Hotel. It is a very high and exterior, and if you see any of my buildings in Spring Creek, this will be built to the same standard, 50-year high architectural shingles. We're going to use real Runarock on the base of the building, not fake. It's going to be with hardy board, that's glass, architectural roofs. The site location you saw, the 4-bedroom unit that you talked about and everyone asked the question on the common amenity housing. It's a 4-bedroom unit with 2 single beds in it. I don't know who went to university. I did my engineering in university and I lived in the dorm with a buddy that I met the first day at school, and there was a single room just like this, but 2 single beds. We did design these, so if it's low season, these 2 single beds can be put together and made into a king bed with drawers underneath, or if it's a couple that work for us jointly, or if we decide to allow the couple to be together because it might work somewhere else, they're able to have a king bed. Each bedroom has its own bathroom. And if you look at the 4-bedroom unit in your plans that you have there, there's 8 single fridges underneath the counter and 8 single cupboards on the 4-bedroom units for them to store their food. There's no dishwasher for a reason. And I know Shane, and someone asked that question, there's no dishwasher. We talked to the Caribou Property boys and they said, don't put patios on it and don't put dishwashers because no one empties the dishwasher. They cook, they clean, they put the dishes back in the cupboard. Do not put a dishwasher in. They'll never empty a dishwasher. It's a problem. So we listened to the Caribou Property Boards. We toured the property. They're the ones that told us 10 to 15% of the housing there would only need parking. That's all they use. Lots of people bikes, and most people walk. And that's where we're located, is perfectly situated for Spring Creek for people that bike. We're going to have over 100 bike parking stalls. So we did move some stuff up top and built, the town asked us to build a building on top. You'll see that in the site plan for bike parking above and some down below. We are also planning, as we do in Spring Creek, we have common bikes that people get to use. And the Malcolm Hotel has common bikes for the people staying there, and Spring Creek has common bikes. So we try to think of everything we can. As far as parking goes, one thing is correct. If this was all considered employee housing, which we originally had an application called employee housing, even the 4-bedroom, we still consider, in my opinion, employee housing. We would only require 28 parking stalls, 24, one per unit as the bylaw, and 4 visitor stalls, and 0 is required for warehouse sales. If you follow the bylaw, it's only 28. Our parking study recommended 34, so we made sure we provided that, and we provided 35. As far as the landscaping goes, it was already touched on by Nathan. We do have screening in front of the parking on Bow Valley Trail. There will be about a 3-foot berm there, and we're planning to use mugle pines. If you look at the roundabout in Spring Creek, those are mugle pines. They're about 6 to 8 feet high. And there's also some landscaping on the landscape plan. You'll see that we're trying to retain what trees we can. The landscaping in the URW, which is owned by the town, will be shrubs. And sorry, I'm not sure if everyone's still there. Okay, the shrubs, we're only required to provide 47 trees and 47 shrubs. We're providing 180 shrubs, and they'll be ranged in size and variety as we've done. If you looked at ever the landscape in Spring Creek, I think you cannot compare anywhere in Canada the same type of quality landscaping. The town did ask us to work with them to build a bike trail and a wide sidewalk, as we did throughout Spring Creek, and they've been doing on Bow Valley Trail. So we've have a cost sharing agreement with them on that, and we're also donating land to the town of Cameron to allow that to happen on the south side of our property, that they will have this multimodal transportation network that we want to continue in Cameron. And with that, it will connect through to Spring Creek, as that people will be able to walk or bike on a dedicated bike lane all the way into Spring Creek, whether they work for us or not. So that's just one other thing on the landscaping. Again, my landscape architect does an amazing job on it. If you look at Spring Creek, same landscape architect. The elevations, I think Nathan talked enough around that we've tried to meet the bylaw where we can. There is some relaxations required because of the design of the building. If we try and give it more steeper pitch roofs, we lose bedrooms or lose height in bedrooms. We lose places for storage or desks and it really gets tight and small. And this building is set back so far from the Bow Valley Trail because of URW, and a setback from the adjacent property owners because of the other URW for the storm pipes. And it's 28 meters from the applicant or the appellant that has concern. So just in closing, I still struggle with understanding the reasons for appeal from the appellant. I think this will be bringing something that is unique and new to the town of Cameron, that hopefully we are a leader in helping the rest of the community build more of this. And I really hope on the Yarmaloy's lands that they see this as an opportunity, not something that is for putting more density, not like some of the buildings in town that are only 1 story on Bow Valley Trails. It's an opportunity to put 2, 3, 4 floors. And I wish there was debt control. I would have went 5 stories, but it's an opportunity to provide more affordable housing that we can staff more people. I don't want to be like Aspen or Vale, where people have to bus in for an hour to work every day. So with that, I ask the board to remember 2 things: your obligation, and that is that this does not unduly interfere with the amenities of the neighborhood. I have seen nothing in it, and it does not materially interfere with or affect the use, enjoyment, of value of neighboring parcels of land. And that is what you as a board are guided by. If anything, everything we've done, I think, has helped the value of the land in the community and also provide opportunities for more opportunities for housing the people that work and live, and they're good people that work for me in the Bow Valley. Thank you.
Mr.
Available for questions.
Let's hear questions from the panel, please. Any questions? None? All right. Thank you very much, Mr. Cook, for your time.
Thank you.
Is there anyone in attendance wishing to speak in opposition to the appeal?
Yep, we do have someone.
Good evening. I'm Sabrina Durando. My husband, Jeff Bellinger, oh, thank you, is here, but he had to leave. Can you hear me now? Yes. We are the owners of Castle Mountain Home Furnishings, and I'm speaking today in opposition to the appeal. Our business is going to occupy the lower level of the 500 Bow Valley mixed-use building, and I don't want to, I'll try to keep everything as distinct as possible, just that we don't cover too much ground. The only points that I wanted to specifically speak to were just a few things. Otherwise, I'll just defer to the McElhaney report. Our development addresses two of the most critical issues facing our community, which is a dire need for staff accommodation, which is recognized in the municipal development plan that governs our community, as well as the retention of a locally owned business like us, which is recognized in the town of Canmore's economic recovery plan, which focuses on business retention and survival during and post-pandemic, and the Business Recovery Task Force mandate to support business operations in the recovery efforts and future growth. We approached Frank, like Frank had said, to help us build our building and get this project off the ground and try to figure out ways to offset some of the financial costs of getting the project moving. And I thought it was just such a great idea. My idea was that he could build condominiums above, and Frank said, I don't need condominiums above, I need staff accommodation for my staff. So this partnership was born between the two of us, and it's been a long and arduous process to get it off the ground. And it's just, my husband and I are incredibly proud to be part of one of Canmore's first major staff housing initiatives. It's a major win for the community. We share, like so many other local businesses, the struggles of people not being able to properly staff their businesses due to lack of available staff, which is fueled by a lack of available housing. So this completely addresses that need. And it is a large scale with an intense use, but I'll get to that later. We're thrilled because we get the opportunity to own our space and to stop paying rent, which was a long-term goal since we took over the business. And I'm a born and raised Banff girl, but Canmore is my home now. And just like the Armloys, I love this town, and I don't want to see the integrity of it compromised, which I don't think this building does in any way, shape, or form. I think it adds to the value of our community and all of the things that we're trying to achieve as a community as a whole, which is trying to bring in some staff accommodation and common amenity housing. So just to address the higher density issue, I can completely understand why the appellants are concerned as neighboring landowners, and that there's a perception that this project might devalue their land, but it's just simply not true. Everything that we're going to do in this area is breathing life into an area that's got nothing currently on it right now, and it's going to revitalize it. We're going to put in a beautiful bike path and a beautiful sidewalk, which currently there's none right now. And it's going to create more pedestrianization and active modes of transport for people in Spring Creek and other areas of the community to be able to access easily, which again is moving towards our goals as a town to try to increase our pedestrianization and active modes of transport so that we can reduce traffic congestion during our peak seasons as a tourist town. And yeah, we just get to continue serving the Bow Valley as we have for the last 30 years. We're the third business owners of this business. So what we're doing here in town isn't anything new. The business has been here for a long time, and it's a very valuable business in the community. We sell large, bulky items, which otherwise people would have to drive all the way to the city to do, and a lot of our customers don't have vehicles. I mean, I can't predict all the problems that could arise with this development. I know that the applicants are very concerned about parking, and there's not enough parking that could potentially spill over onto their vacant lands. And I just look at the amount of parking that we have. I think it's perfectly sufficient, just like the parking studies have demonstrated. And even just to kind of move in with the, the integrated parking management plan, which was what we, as we approached the building and started looking at what our parking needs for the building were, it was the town's integrated parking management plan that we focused heavily on, looking at all of those solutions that were laid out and the potential strategies of that plan and how you can use the limited space that we have here in town, but maximize the utilization of the land for it. So one of the biggest strategies was shared parking, which I don't want to go into this too much because I gave everybody one of these, but we knew that during the day, we might be using a few more spaces during the day, but when we leave our business and we go home for the evening, it frees up any of those spaces so that the staff accommodation residents can use it as well, and vice versa. If there's an instance where sometimes our customers are using more of those parking stalls, it's a mutual agreement between Spring Creek and us. Also, with this building, we get to offer wheelchair accessibility for our store that we currently do not have. And also, too, just to address again the issue that there's this perceived threat that there's just not enough parking stalls. A lot of the seasonal workers that are going to be living in the residences upstairs, they're seasonal workers, so they often arrive to town and they don't have vehicles. Some will, obviously, but for a large majority of them, these are the most seasonal workers. They don't have vehicles. And also, I think when we see all these policy changes with the paid parking system that went in this summer, and that the monies from that paid parking are going to get earmarked towards increased Rome transit infrastructure, and that we're just going to see the community get even better serviced by the Rome Transit than it already is. We're just going to see those staff accommodation residents not even want to later down the road purchase a kind of, a beater vehicle so that they can get around. There's not going to be the same need for it because they're going to be so well serviced with the transportation system here in town. And I just think more parking stalls is not the solution for our parcel of land, and it's not part of the solution for Canmore in total. It's really moving towards an adoption of active modes of transport. And then my last point is that in terms of addressing the applicant's concern about is this parcel of land the right and the intended use of space and utilization of the land, I would have to say that it's 100% the best utilization for the exact parcel that we're on. And that is because it perfectly aligns with, again, our municipal development plan. 500 Bow Valley Trail is one of the most ideally suitable locations for a development project of this kind because all of the residents living in the staff accommodation units are ideally positioned in the heart of Canmore. They can easily access transit stops, the town center, and grocery stores. And to reference, it's 5.1.2 of the municipal development plan. It states, affordable housing should be integrated and distributed throughout Canmore's neighborhoods with preference given to locations within reasonable walking area of the town center, commercial and mixed use areas, and transit stops. And that's it. Any questions?
Thank you very much. Does the panel have any questions for Ms. Toronto?
I have a few questions.
Okay.
Let's say I've never been in a furniture store. How does a furniture store works?
How does our furniture store work?
Yeah.
So we are predominantly a custom furniture store. So our showroom is housing large, bulky items, a sofa, love seat, beds, mattresses, appliances, dishwashers, all of those things. But so our appliance side of it aside, if you were to walk into our store, typically people are looking to furnish a full home or just buy a sofa, love seat, kind of smaller items. But we don't, we do all of our deliveries. We offer free delivery within the Bow Valley and Banff, and even sometimes to Calgary. So people aren't often driving to our store and walking out with anything. We don't sell anything off of our showroom floor because we have to deliver it, and we use our showroom as the opportunity to showcase the large good, and then people can choose whatever fabric and design style they want, and then we order it, and it comes well wrapped, and then we deliver it to the location.
That's actually where my question is going. So I'm not coming to the furniture store, I buy a sofa and I take it with me?
No.
So it's happening, or you explain to me how
There's
it works.
we only carry one, so we carry all Canadian-made brands, except for one. Our one brand that we carry is called Ashley Furniture, and that's for lack of a better term, it's a mass-produced product. It's not made per item, and that we carry that brand so that we can service, I guess, it's a more entry-level product, so it's cheaper. So we sell that. It's only available in one color, one or two colors, and that gets stocked in Calgary directly. So that's the only item that we'll actually sell off of our showroom floor, because we can get it back in from Calgary within about 2 weeks, and then it replaces the big hole that gets left on our floor.
So the way is I come into the furniture store, I pick a sofa, I pick a color, I pick a material, it will be ordered, and then it will be shipped to the store? Will it be shipped to the customer directly?
No, it comes to us first. We receive it in our warehouse, and then our delivery boys deliver it to the customer as part of the final mile delivery service.
So how does the delivery works then? It goes back to the parking and delivery and the lodging. So what type of truck is it, or?
We have a cube truck. We actually have 2 cube trucks. We have one, I can't recall what the exact size of it is. My husband usually deals with that portion. And we've got the loading facility, which is laid out in the design plan. And there's also, we didn't actually cover that in the plan, or maybe it wasn't referenced at all, but there's actually a very well laid out portion where our trucks would move in and then they back up in order to get out, because there's not a direct throughway to get all the way in and out. There's a, Murray, what's it called, like a back-in feature?
We did an analysis of a truck turning radius, and in the one corner of the property on the site plan, you will see...
Sorry, yeah.
He'll explain it way better than me, too.
Hi, my name is Murray Freeman. I'm with MTech Designs. I designed the building. So in conjunction with McElhaney, we did a truck turning diagram on the site. And in the lower corner of the site, where the parking comes up, you will see there's a little open space where we created. And that is designed so the truck can come in, pull its nose in there, back into the loading, pull it back in there, go up the parking, and then back out. This is because a second entrance off of Bow Valley Trail was deemed not something the town really wanted. So they did not want us to have a through access. They wanted our access off of Spring Creek Gate, so we modified how we were doing the parking and the site to allow for that truck turning and getting into the loading dock. The loading dock is also slightly lower, so the truck can back right in and be right at the same level.
Perfect, thank you. I have one more question, maybe for you, sir. So I'm coming with my truck out of the parking lot. Can I turn left or right only?
Is there that middle meridian with?
On that street, I
think it's Spring Creek Drive.
Is there a medium?
Or do the truck has to turn into Spring Creek?
There's a break at that point, so you can turn left or right.
Right, there is.
Coming out of that
So
space.
the truck's not
not having to go through Spring Creek.
That's my
to go-
question.
No,
Okay.
it can turn directly back out to the roundabout.
Thank you.
Which for us too, this is actually so much, it's just a greater positioning for some of our trucks coming in too, because they'll be coming directly off of the closer access point from the highway. And also, it alleviates a whole host of issues that we already have with our trucks that come and drop off our goods. Currently, right now, so many of the trucks have to actually pull, I don't know if you know the location of our store right now, but we're on Railway Avenue, and there's the set of trees with a large berm. Oftentimes, all of our trucks pull across, and physically get out and they walk over the berm to figure out how they can get into the back area of our existing building. So that's it.
I actually have a
Any further
question.
questions?
How many people would customers occupy your store at one time, roughly, in the new 10,000 square foot space?
So it's the same amount of space that we currently have. It seems like a lot of space, but it's really not a lot of space when you're selling big goods. I would say as an average, because of the nature of our business, we don't carry small little knickknacks. We're not a store or a destination where people are going in and out of to buy small little things. Like the smallest things we carry are towels and sheets. We really only ever see a maximum of 2 stalls getting used outside of our own staff vehicles, like at a time. Even if we're running a Black Friday event or a sale, we will never see more than 2 parking stalls ever get used at one time.
And how many stalls will your staff use?
Our staff, they're currently using 2. My husband and I constitute 40% of our workforce. Our other 2 staff members live close downtown and they walk, and then our other staff member, they bought an electric vehicle this summer. And we don't really have any, our only turnover staff, that's our core staff, and our warehouse staff is the portion of our business that revolves. It's a revolving door frequently due to staff accommodation and other issues. And they typically don't ever have vehicles because they're fresh from Australia or New Zealand or wherever they're coming from.
Okay, so two stalls for staff?
2 stalls for staff and typically 2 stalls for customers.
Nice, thank you.
I have an additional question to this one is how many people are currently coming into your store roughly per day? Customers?
Per day?
Per hour?
Oh, per hour?
200?
No.
10?
Per hour, probably 3.
So opening hours are
10 till 6.
8 hours, so 24 customers a day?
I would still say that would be high. We're appointment based for the most part too. So
What does that mean?
So like a lot of times right now, because of the how many new builds are going on in town, there's a lot of people that are doing full home furnishings, so they'll make an appointment with myself or with one of my other sales staff so that they can get one-on-one attention when they come into the store. So typically in a day, I would never take more than 2 showroom appointments, and the same with Beck. She would only take 2. So, and that almost constitutes my whole day in the store, would be 2 appointments.
So if I'm
Plus
going,
whoever's coming in and out in between.
so if I'm going to a grocery store, I'm taking 30 minutes of my time. If I'm going to a furniture store, I usually take
3 hours.
3 hours? Okay.
Yeah.
Okay. Thank you.
That's it.
Any other questions? No questions for Mr. Rondo? Other than the letter from the furniture store, from Castle Mountain Home Furnishings, are there other correspondence in opposition to the appeal?
No, nothing further. Does the board wish to accept the written submission provided by Castle Mountain Home Furnishing, which was provided at the start of the appeal hearing.
Board moves to accept the correspondence and add it to the agenda package. Those in favor? And motion passes unanimously. Madam Clerk, if we could add that to the record. Is there anyone in attendance speaking neither in favor nor in opposition of the appeal?
Doesn't look like it, Mr. Chair.
Is there any additional correspondence either in favor or neither in favor or opposition to the appeal?
No.
Taking a temperature check, do we need a brief recess or shall we move on to the closing remarks? Is that a yes for a recess or a yes to move forward?
Move on.
All right, thank you very much. We'll ask the administration to provide any closing remarks, comments, or clarification that they might have.
Hi, Clara Lick, Transportation Engineer. I'll add a few closing comments as they relate to transportation and parking, as that's been an item that's come up a little bit this afternoon. So I'll speak first to the site context and the location. It's very well connected by walking and cycling infrastructure, as has been mentioned. The developer will be completing offsite improvements, and the town is also going to be completing some infrastructure improvements to the sidewalk and bike path along both frontages of the site, so connecting up Bow Valley Trail as well as along Spring Creek Drive. Across the street from the site, there's currently a free local transit stop as well, which accesses town center commercial, grocery stores, and a number of other key destinations in Canmore. There's excellent walking and cycling connectivity through the area in general. There's also a potential for seasonal transit servicing through Spring Creek Mountain Village, which is a community where we're seeing some of our highest shares of walking and cycling in town based on how that infrastructure has been designed and built to date. And that's also a destination for many of the potential future tenants of the site. Yeah, generally speaking, in terms of the built form, the proximity of dense land uses in the surrounding area, all of these are factors which contribute to a high proportion of trips being taken that don't rely on people needing to have an automobile. And for those reasons and the anticipated scale of the impacts, the town didn't require a transportation impact assessment for the site. That's at our discretion based on the type of development that's being proposed. And given also the high proportion of trips that we expect to see to walk, that will rely on walking, cycling, and also based on the parking supply on site, it's the town's feeling that the anticipated impacts of the development can be reasonably accommodated by the transportation options that are being provided in the surrounding area. In terms of overall plans, we do have an integrated transportation plan which guides the overall direction that we're moving within town. This includes mode shift and providing that mix of travel options that I've just mentioned. The parking study as well, which has been brought up, was completed by the engineering team at McElhaney. That's been accepted as reasonable by the town, and they are meeting the requirements identified by that report on their site. With that, I'll pass it over to the planning department for any additional comments.
Is there any comments for Claire? Questions for Claire? No? Okay. Okay, just a few closing remarks from the planning end. So I did want to point out, as there was a lot of comments by the appellant about the feel, the idea of it. That would have been a discussion point when the amendments to the Bow Valley Trail Area Redevelopment Plan were occurring last year. That went to council. There was a public hearing in which anybody could come and give their thoughts and opinions on. As part of that process, all of the landowners in the Bow Valley Trail General District were mailed notification of the upcoming public hearing. We received no comments or no letters in objection, and no one spoke at the public hearing in objection to this concept. The uses proposed as part of this concept or part of this application are consistent with the concept that was brought forward as part of the Bow Valley Trail ARP amendments. There's a few differences such as the access piece, but that was expected that there would be some changes to the site and the building based on detailed design. So that's not viewed as inconsistent or significant from what was shared with council. There were some concerns expressed by the appellant about the number of variances. From administration's perspective, there's no limitation on the number of variances we can grant. As far as we're concerned, it's kind of irrelevant. It's what is the rationale for it, what is the impact, and what is the trade-off? I mean, if there's no material impact and we're getting something that's achieving the same goals or it's better, in this case we've got a social benefit through the type of housing that we're looking to increase in the community. There's an environmental benefit with the project. It's got geothermal heating. I mean, that's a pretty substantial environmental benefit for this type of housing. It's going to have high quality landscaping. There's a high quality common amenity space. It's achieving the goals that we're looking for, even if it needs variances. And as the applicant mentioned, there was an interest in originally doing a direct control district. The town's land use bylaw discourages direct control districts where we feel a stock district can be used, even if variances are needed to achieve what's being proposed. And so that's how administration recommended proceeding, was trying to make the stock district work. So I think some of the variances here, if you'd done a DC district, and I'm speculating, but if you'd done a direct control district, you know, they would have built all this stuff into their district and they would have no variances. So, you know, it depends on how you look at it, I suppose, but the administration wanted them to use the stock district, and as pointed out, as a result, the incentives that are there are available to all landowners who has vacant land. If they want to go ahead and add common amenity housing to their development, they can take advantage of some of those bonuses. It's available to them. So it's really viewed as adding, as a positive addition to the district. And that's it. That concludes my comments. I'm not sure if Ms. Miller has anything to add. No? Okay.
Thank you very much. Any questions for the town on their closing remarks? Seeing none, thank you very much for your presentation and your comments. Does the appellant have any closing remarks, comments, or clarification to make?
I actually do have a question for the town. Granting variances on eave heights, is that a very common, do you approve that a lot?
It comes up from time to time. Skyline Peaks had an eave line height variance in the interior similar to this. So and
variances where the percentage of the eaves is as high, like most of the eaves on the building. Like it's at 11 meters, I believe, and the bylaw is 7 meters. Is that correct?
Bylaw starts at 7.
It starts at 7?
So yes, if you read the district, I believe it starts at 7, and then there is there's an increase for the common amenity housing up to 11, which was approved as part of the amendments to the land use bylaw.
Great, thank you.
All right. Does the appellant have any closing remarks, comments, or clarification?
Thank you. And thank you for listening to me earlier. I get passionate about this and carry on. We had a PowerPoint presentation, and I'd like at this time to see if we could submit that for your perusal during your decision-making process. Basically, we identified a lot of the things that I talked about, the specific changes in the zoning and that type of thing. It was what Melissa was going to present. We didn't get a chance to technically get it onto the screen for you. And it didn't get to the PowerPoint presentation. In closing, we really wanted to, is this closing statement now? In closing, I think the key element here is that we support the common amenity housing. We support the need, and we recognize the need for staff housing. We understand, the importance, and we like the commercial aspect of this project. Building out this project, I feel that it's an overbuild for the property. But having said that, the impact will be felt down the road after the fact, after the build. We feel that 400 Bow Valley Trail right now is one entrance to it. It's 5 times the size of the property. We're going to be now forced to look at working, and we can work with McElhaney in the town of Canmore on a secondary entrance, probably right across from Kananaskis Street. We would like to see a traffic impact study done and how the influence of the build out of that whole area is going to affect the traffic from that traffic circle and through across the tracks, the stacking from the tracks on a left turn, right turn, those type of elements, because they are going to affect us. As far as the amenities and that's concerned, we like the direct control so that we realize that what's happening with the intended use of that building carries on as rental. The definitions are relatively loose, but they're new. You're going to be able to change those. Right now, I could read common amenity, and every duplex, every threeplex, fourplex is common amenity. You got a private bedroom, and you're sharing a bathroom and sharing a kitchen. That's not the goal and the intent of common amenity. Again, it's to respect the privacy, a private space to sleep, and then shared accommodation so that you can densify that. I understand densifying financially a piece of property. We are not interested in picking on that design. We just wanted to go on record that there is a parking strategy problem there, and although it falls within the guidelines that are in front of you right now, we believe that it's going to affect that whole area, and we wanted to go on record for that. And the sum of the whole thing is really, it's good to have that type of building. Every argument for that building we agree with, but we never did really discuss the massing of the building. We never discussed, what actual parking requirements are for 185 people. We never discussed, the amenity and the use and the actual access to the amenities. Yes, they're provided, and yes, that. And again, as in this appeal, we just wish this project luck on that. We're glad to see the delivery of everything. We want to go on record that there's a problem there, and most importantly, we want to go on record that the traffic impact is important to us. Thank you.
Thank you, Mr. Cooch. Any questions for the appellant? Seeing none, I'll move on to the final question.
Mr. Chair, apologies to interrupt. I just would like to ask whether the board would like to accept the PowerPoint presentation referenced by the appellant, as this was received today.
Sorry, I didn't catch that. Just clarifying, if the board wishes to include the PowerPoint?
Correct, yes.
I move that the board accept the PowerPoint presentation and include it in the record. All in favor? That was unanimous. The motion is carried. So final question for the appellant.
So, sorry, it's not unanimous.
Sorry, was that?
It is not unanimous. Oh my God, can't say the word.
Oh, sorry, I saw a third hand there. It's carried to 3-1. Majority, what?
3-1 is correct.
All right, thank you. So final question for the appellant. If I could have Mr. Cooch or Ms. Yanalo respond to this. Does the appellant feel that they've had a fair hearing? Have you had an opportunity to be heard, and are you satisfied with the process? Yes? Thank you.
Thank you. Yeah, our answer to that is simply yes. It's been a fair hearing.
Thank you very much. This hearing is now concluded. In accordance with the provincial legislation, the board is required to hand down its decision within 15 days from today's date. No decision is binding until the board issues a written decision. I move to adjourn today's hearings. Those in favor? Motion carries unanimously. That concludes our hearings today. Thank you very much. The board will now move in camera